10-4, my lord. So therefore, I'll be praying, my lord, if your lordship kindly, my lord, accommodates me so that I can move the application.
Appearing in the monthly, appearing in the list.
No, my lord, I want to leave. I want a leave to file and move it, if possible, as an unlisted motion after serving the state respondents.
File today and give the number. I'll fix it on Monday.
My lord, I would be requiring a leave so that I can short serve, because they will not be taking the filing until there is a leave.
It's Friday. You get 48 hours. In
Well, 48 working hours. We are not satisfying that.
28th is the demolition day.
Yes.
Leave granted.
28:10 a.m. That is the.
Lord, may I mention, my lord, in regard to item number 538, my lord.
Yes.
Identical matter, my lord, several matters disposed of by your lordships. If your lordship kindly take up this matter.
Give the
My lord,
number.
may I be permitted to mention one hearing matter for inclusion, my lord? Your
Affidavits are complete.
yes, complete, and your lordship have given liberty to mention.
My lord, may I permit to mention one matter, my lord, in a combined list, my lord. It was in a daily list. I preferred on time, my lord. So, my lord, your lordship, thereafter, my lord, it was gone to the monthly list. My next day, my lord, your lordship, take it.
My lord, I am praying for upgradation the list, my lord.
This is the monthly list.
Yes, ma'am.
Give the number.
My lord, may I be allowed to mention, my lord, 5 applications in the same writ petition, my lord. My lord, previously I mentioned, my lord was pleased to allow. Later on, it was found that it has been dismissed for default. So our fresh restoration application and condonation of delay has also been filed. There are 5 applications, my lord. Restoration, condonation of delay for restoration, substitution, application for setting aside of abatement, and section 5 for substitution also.
So you've delayed in every step.
In every step. And it's a change brief, my lord.
Give the numbers. Applications, Lady.
Only application.
My lord, item number 180 of today's list. My lord, last Tuesday I mentioned, my lord, this is regarding, my lord, HON'BLE property. 90 years lease, my lord, granted in favor of our, my lord, pro-grandfather. Now, my lord, up to 2012, my lord, we have paid the, my lord, tax. But this year, my lord, they issued, my lord, 100 times extended the tax. My lord, we made representation, same has not yet been considered. On the other hand, my lord, a notice for, my lord, the cancellation of the deed has been issued, which will be expired, my lord, on 29th. I have served notice, my lord.
দিদি এটা সোমবারে উপরের দিকে রেখে দিন
180 একটু পরে দিচ্ছি আমার
Yes, call the days list.
Item 1.
The writ petition has been allowed. I'll read out the relevant parts. Clause 8 of the deed enumerates that if the second party, the respondents, is/are found to keep the property without proper protection and maintenance, in as much as the house may collapse and be destroyed, the petitioner will in the first place approach the authority for proper action, and the authority having failed to take action, the petitioner will be entitled to adopt a resolution for taking back the property from the second party without any compensation for any development or improvement of the property, and the second party will have no objection and will be liable to deliver possession of the property to the first party. In terms thereof, several communications were made by the petitioner to the respondents, but to no effect. By a letter issued on 25th October 2010, the respondents stated that the minister in charge had agreed to the proposal of the petitioner for return or release of the property in principle, and the petitioner was requested to take a resolution in this regard and send the same to the department for consideration. Pursuant to the said letter, a resolution was taken by the petitioner trust on 1st February 2011. There being gross violation of the terms of the agreement by the respondents and the petitioner having acted in conformity thereof, the writ petition be allowed in terms of prayer A. The respondents are directed to release/make over possession of the property in question, being Gangadhar Niloy Panchshala, in favor of the petitioner in terms of the agreement upon execution of a formal document to that effect within 4 weeks from date. The maintainability issue has been decided in your favor.
Urgent photostat certificate copy. Grateful.
Grateful to your lordship.
Item 2,
Yes, what is the
Not,
correction
I am for the
required?
Not correction is not your lordship directly dispose of, no, no, it is not lordship. Dispose of the matter not by the respondent number 3, it would be not respondent number 4.
Have you served the other side?
Not I,
Who is appearing for the respondents?
Paraswar Bhyankar Ganguly, it could be private respondent. State name. State is not appear. No, no, assistant. Assistant engineer, PWD.
Oh, it will
This
be
one
the
also
fourth
served.
respondent.
This one is 4.
Inadvertent error has crept into the order passed on April 24, 2023 in the second paragraph of the third page of the order, comma. The third respondent be read as the fourth respondent. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on April 24, 2023. Urgent certified website.
देखा 3 number आ गया
item 3,
3 minute same thing lot that we have same
3. What's the correction?
the same thing instead of 3 it would be 4.
Let the correction be made. Inadvertent error has crept into the order passed on June 23, 2023. Paragraph in the third and fourth paragraphs of the order, comma. The third respondent be read as the fourth respondent. The department is directed, we'll ask the implement.
Grateful.
But item 4, Malad, I am for the petitioner. Malad, matter has been settled out.
So you
of
want to
court.
withdraw?
Malad.
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further since the dispute between the parties has been amicably settled. Paragraph in view of the above, the writ petition being such and such is dismissed for non-prosecution. There shall however be no orders to cause urgent certified website copy.
item 5,
I am for the petitioner, ma'am.
Yes.
A restoration application along with condemnation of delay, every party has been served by an affidavit service is there.
You have served the
I
respondent.
have served my affidavit service there and item received. On 23rd, 8 item is received, my lord. I have given that details, my lord. Matter is of 2010, my lord. It was never heard. All on a
Land matter. Land matter.
Land matter.
2010 dispute is not of determination at all.
No, no, my lord, item, it came in the warning list of your lordships. It came in the, appeared in the warning list of your lordship.
Is it a group 1 matter?
Group, no, my lord. It is a group 9 matter, but your lordship dismissed it. Because as it is old matter, my lord, 2010, it appeared before your lordships in the warning list.
How can a group 9 matter appear in the warning list before this court and we
My lord, it has appeared. I'm just. It appeared in the list, but I'm placing the order, my.
It's not a residuary matter that has been recorded in the earlier order. It is not.
And
a
then it
Group
may
9
be,
matter.
in my brief, it is written as residuary. Anyway, my lord, it appeared in your lordship's warning list.
It is a land matter.
Land matter.
I'll restore the application, the writ petition, but I do not have determination to deal with 2010 matters. This code deals with 2017 onwards.
71. Then, my lord,
So I'll release it.
so far as restoration, my lord,
I'll restore it because it's my order. I'll restore it and release it.
as your.
Put it to warning list.
Then restoration application will be disposed of.
May 17 তখন তাহলে determination টা হয়নি ছিল affidavit of service.
Condonation of clear আছে।
Can 2 of 2023 প্রথমে। The petitioner prays for condonation of delay in filing the restoration application. Paragraph, good grounds being shown, comma, the delay is condoned. Paragraph, can 2 of 2023 is disposed of. Can 1 of 2023, this is an application for restoration of the writ petition which was dismissed by an order passed on May 17, 2022. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on May 17, 2022 is set aside. Paragraph, the writ petition is restored to its original file and number.
Order application restored.
Can such and such is disposed of. WPA te order korun. The writ petition is released due to lack of determination.
It's a land matter, my lord, but
It's a
2000
land
onwards 2070, my lord is taking them.
Yes, 17 onwards I'm taking. But actually land তখন হয়নি জিনিস নাহলে তো এই কোর্টে আসবে না।
Item 6.
What is my application for restoration, my lord?
Item
Have you
6.
served Mr. Dikhe?
Mr. Shupratim Dhar is appearing,
Yes,
my lord.
yes,
He is in some
Hello.
difficult,
Restoration
restoration. He's in some difficulty in the first half.
within time.
My lord, yes, my lord, both the Bankura municipality and Mr. Mondal has been served, and Mr. Dhar has been served.
No, your application is within time.
Yes, my lord, within time. My lord, on the day of dismissal, my lord, it was mentioned immediately thereafter. But your lordship was pleased not to entertain, make an application.
Can 1 of 2022. This is an application for restoration of the writ petition which was dismissed for default by an order passed on November 22, 2022. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on November 22, 2022 is set aside. Paragraph, the writ petition is restored to its original file and number. Can such and such is disposed of. Paragraph, WPA te order korun. Let the matter, group 1 motion.
Group one motion.
Let the matter appear under the heading group 1 motion on 18th September.
18 September এ থাকে।
Next.
7.
For 7 and HP lot, both the two matters, I beg to appear for the.
Yes.
I am for the respondent number 2 and 3.
But one order, the lordship has been pleased to dismiss the 2 writ petitions, that's why 2 applications.
Restoration.
Lord, this is a recalling of your lordship's order dated 16 June. There was an observation that the petitioner does not want to proceed with the matter or not interested with the proceed with the matter.
Yes.
This is the observation.
Because
Lord, I
several
want to-
assignments were taken, yes.
Yes, my lord, admittedly, my lord, on that day when the matter was, my lord, dismissed, my lord, for non-prosecution, my lord, my learned advocate on record, my lord, was not present due to her illness. Lord, I was, my lord, not in Calcutta, in the outside. I was in outside Calcutta, I have stated in my petition. Lord, if your lordships kindly only one thing more, my lord, I will submit. Your lordships kindly have a look of the not page 16. Page 16
Of the,
of the recalling application. First 15, your lordship can
Yes.
go first 15. Now 15, your lordship has been pleased to direct the concerned authority to produce the document. Not till the date of dismissal, not they did not.
this is on merits.
But anyhow, I know.
Several adjournments were granted, a last chance was granted.
Right,
After
right.
that
Absolutely
also,
correct.
there was no.
But that is all, that is fault on our way.
That's not my lordship's submission, that it is my fault. Court
Yes,
has already granted
obviously.
2 times.
Obviously, I could not appear before your lordship.
My lord, kindly allow the restoration.
Mr. Dey is appealing for the state. Have you been served
you.
with a copy?
Yes, yes, yes. Copy has been served. Mr. Dey is there. That's
You have
not.
made 2 separate applications.
Yes,
You
yes,
have
2 separate.
one order, 2 petitions were not dismissed for non-prosecution. That's why 2 applications.
Yes, because they are analogously heard.
But 2
One
applications.
application would have sufficed actually. Anyway.
Anyhow, one order will cover 2 applications.
I find 1 application. Where is the?
No, there is another application also. Milord.
Copy দাও আমার একটা কপি দেয়
Can
না দুটো দেয়নি
And one.
একটাও দেয়নি তো এই এখন নেই আমার বলা
And 1 of 2023. Common.
আমাদের ইয়ে সৌমিত্র দাস আছে
This is an application for restoration of the writ petition, which was dismissed for non-prosecution by an order passed on June 16, 2023. Paragraph, sufficient grounds being made out. The application is allowed. The order passed on June 16, 2023 is set aside. একসাথে করুন applications but same order এ হয়েছে
কপি কি হবে
একটা সেটা করে আবার সেটা চেক করে করুন
কপি কি হবে না না হোটেলকে আমরা বলে
non prosecution আছে ওখানে অর্ডারে তাই আছে ডিফারেন্স কিছু নেই দুটোর মধ্যে writ petitions, restoration of the writ petitions which were this. Paragraph petitions being are restored to their original file and number. Paragraph, the applications are disposed of.
কারণ আমার কাছে খবর হচ্ছে আমাদের
Being planned 1 of 2023 are disposed of.
হয়েছে
WPA তে order করুন. Are you ready for hearing of the writ petition?
Yes, I'm ready. I'm ready. Any develop should to lordship.
Not now, I'm asking.
No. I am. I say that any day. No. Not. I am ready, my lord. I say, my lord, that as your lordship know when should to your lordship the date. I'm not saying that.
My lord, the whole crux of the matters depends for the report submitted by the BLRO for demarcation. If demarcation report is there, everything will go. So that's the main thing.
Come back with the report on the.
Yes, that's why your lordship grant some time so that my learned friends can collect the report.
Same heading on 22nd September. Let it appear.
No, demarcation.
Demarcation has yet not been.
Demarcation.
That's why, my lord, I want to show your lordship the 2 orders.
আমরা বলছি ডিমার্কেশনটা হলে এত বলার কি আছে জজ সাহেবের অর্ডার আছে ডিমার্কেশনটা আনে দিলেই হয়ে যায়
Demarcation.
Has filed a report.
yes
Well, thereafter, the order
no,
was passed by
report
your
was filed only demarcation
demarcation was not done and the document was not produced.
An exception which has not been used.
yes not
Exception.
Yes.
I've already.
You've used.
I have already used the exception. I've already used the exception. Exception is also there.
no
After passing this order, not after submitting this the report, Lord, your lordship was pleased to direct on.
no copy was sir exception copy
There
I
should
did
be.
not find an exception in the report.
Yes, not I
they
have.
have also
I have.
not will receive
No,
any
no, I have. But I have submitted as I understand, my lord.
very good let a
Then have
copy
you
be
filed
sir
the exception?
Not.
there is nothing in the file
No, no. জিজ্ঞেস করো করেছে বলো some exception affidavit in reply of the writ petitioners to the report on affidavit of the respondent number 5.
When have you filed it?
I have filed this.
Because I do not find it on record.
I can submit. This is 8th November 2021. 8th November.
Report was submitted on 22nd December 2022.
No, then this is I think second report. Your lordship is talking about the second report.
First report, the first writ petition, first report.
In the first writ petition.
Yes.
Report was filed on 22nd December 2022. And no exception has been filed.
Government.
No, then, my lord, I think, my lord, I have to file the report against the second,
Filed now.
against that report.
So let it be on after Puja vacation.
No, after Puja vacation. No, my lord, no question of after vacation, my lord. I will take only 7 days time to file the report, my lord, exception to the report.
1 hour to 2 hours.
1 hour to 2 hours.
Appear on 22nd September if it has not completed.
Yes, yes, yes. Well, grateful to you.
I cannot give such a long.
Yes, yes.
Group 1 motion on, let the matter appear under the heading Group 1 motion on 22nd September 2023.
My lord. A copy. Oh, exception. Right? Yes, not file any exception.
আমি রিপোর্ট এক্সেপশন ফাইল করব না
Item 11.
কোথায় কোথায় 11 বলেন ওটা এক্সেপশন কোথায়
11 তো
Matter, my lord, in which the lordship directed not the state government to finalize the proposal given by the BLRO regarding not finalizing the proposal of the BLRO and settle the land in favor of me. They filed a review was dismissed. Now, my lord, contempt was adjourned in view of pendency of the review. Now, my lord, the
Review has been dismissed.
review has been dismissed.
So they have to
Thereafter, we have
comply.
complied with the order. We have filed an affidavit of compliance.
They have
They have
rejected.
taken exception to the affidavit of compliance.
kindly takes up the contempt petition, my lord. Page 85.
The proposal was directed to be finalized.
Finalized.
What does the
Now kindly take up the exception, my lord.
একটু পাঠান তো এই কাগজগুলো পড়ে গেছে।
Affidavit of compliance.
কাগজগুলো একটু তুলে দাও প্লিজ। Thank you.
Lord, kindly allow me to place now the second paragraph of your lordship's order dated 9th of March.
Yes, I've seen it, yes.
It was subsequently observed by the Block Land and Land Reforms Officer Faridpur Durgapur that the erstwhile lessees had no right to execute the sublease in favor of the petitioner and have therefore lost their right, title and possession over the plot in question. The authority further observed that long-term settlement would be granted in favor of the petitioner. Such proposal was forwarded to the Additional District Magistrate, District Land and Land Reforms Officer by Block Land and Land Reforms Officer by letter dated 16th November 2017. Petitioner submits that the said proposal has not been finalized till date. It is submitted on behalf of the state respondents that the second respondent be directed to consider the proposal made in favor of the petitioner by BLLRO within the stipulated time. Upon consideration of the submissions made on behalf of the parties as well as the material on record, writ petition is disposed of, directing the second respondent to consider the representation submitted by the petitioner and the proposal of the Block Land and Land Reforms Officer dated 16th November and finalize such proposal in favor of the petitioner within 2 months from date of communication of this order in terms of the proposal dated 16th November. After considering the materials on record, this order was passed. I'm led by Mr. Shoma Majumdar in this matter. May he take over.
Kindly permit me. Two things are very important in this order. But as Mr. Banerjee was placing before your lordship. Kindly takes note the paragraph beginning with the words, it is submitted on behalf of the state respondents.
Yes.
Now, this was the submission made, and to that extent, the state government had no reservation insofar as the writ petition was concerned. Please see. It is submitted on behalf of the state respondents that the second respondent be directed to consider the proposal made in favor of the petitioner by the block land and land reforms officer within a stipulated time frame. So thus far, the state had no objection. Upon consideration of the submissions made on behalf of the parties as well as the material on record, the writ petition is disposed of, directing the second respondent to consider the representation submitted by the petitioner dated 31st January 2016 and the proposal of the BL and LRO dated 16th November 2017 and finalize such proposal in favor of the petitioner within 2 months. So what the state wanted was disapproved by this honorable court. The state wanted a mere order for consideration. The court directed you consider but favorably consider. Now by passing the order, which is in the nature of a show of compliance, law is well settled that if a fresh order is passed, this gives rise to a fresh cause of action. But this depends on the nature of the order passed in purported compliance. If not, the order of the commissioner or not the authority passed on remand seeks to overreach the court's jurisdiction or order, then it's clear case of contempt. Please see now the compliance affidavit filed before your lordships. Once again, what the state wanted was expressly turned down by this honorable court. The court wanted a mere remand of consideration. The court said you consider it favorably in terms of the proposal.
And the proposal has been ignored in its entirety.
Yes.
Let us hear Mr. Siddiqui, because this is not compliance at all.
Yes. Please see not only what the authority has done at page 13 of the compliance report.
Yes.
I need not trouble your lordship with the first 2 paragraphs. This is really recital. Then second paragraph on that page. Whereas the state of West Bengal filed a review application being some number so and so in respect of the order of 9th March 2022. That's the principal order passed in the writ petition. And whereas on 24th February, the honorable court was pleased to dismiss the review application after observing inter alia, it is crystal clear from the order itself that no proposal in favor of the petitioner was directed to be issued by the court, and the proposal which was already in place was only directed to be finalized. In compliance to the said order dated 9th March 2022, notices were issued with a department's letter dated so and so. Then it takes care of the procedural hearing and all those things. Now please turn over the page to the sentence beginning with the words heard the parties at length and gone through the documents, records, etc. Your lordship has kindly got that?
Yes.
The fact of the case as it is revealed from the available records is mattered below in brief. Please take clause E. On 9th March 2022, the Honorable High Court, Calcutta, directed the undersigned to consider the application of the writ petitioner dated 31/1/2016 and related proposal of the concerned BL and LRO. But this is completely
That is not a fact.
not the fact. But he is willfully misreading the order. Apropos the previous page where he consciously writes what the review order was. In his writ petition being WP number so and so, present petitioner has annexed a copy of the solemn order of 28 April 16. Then it goes on to the merit of the case. And finally, please turn over to page 15, the penultimate paragraph on that page, the sentence beginning with the words, the proposal of the BL and LRO. The proposal of the BL and LRO dated 16th November 2017 is in ignorance of the law as well as in facts. The BL and LRO concerned failed to appreciate that the very induction of Sri Chai in the land by the Chatterjees is wrong and or unlawful. The Chatterjees did not have any right to grant sublease to any person either in terms of the lease deed executed by and between the Chatterjees and Maharaja of Burdwan, or in terms of the order of 1960 passed by the Honorable High Court, Calcutta. The learned advocate also failed to traverse such facts. As such, the proposal of the BLLO in favor of the petitioner is liable to be ignored in its entirety, and therefore the same cannot be accepted. But he was sitting in appeal over your lordship's order. But this is not a subsequent development or a new policy or a new rule which has come into place after the passing of the order by this honorable court, that the authority would take consider of such subsequent fact or events. But all these facts were deemed to be considered, taken into consideration, then the proposal made in favor of the petitioner for the purpose of his residence over the plot of land. But nature of an order depends on the spirit of it. But when your lordship's courts passes certain orders, But this has to be obeyed not only in letter but also in spirit. Now, the spirit of the order has been clearly undermined or sought to be frustrated by overreaching or sitting in appeal over this honorable court's order, and that's how the contempt is maintainable. And it's not a mere case where I shall have to file a fresh case for agitating a fresh cause of action. But this is
Their
one
option
aspect of
was
the.
to go up, prefer an appeal, which they have not done.
They could have preferred anything. Took a chance by filing a review. Number one. Number two, apart from overreaching the court's order, the second part is not what happens if your lordship is persuaded or satisfied to hold that they are guilty of contempt. Is it only punishment or it's also retributive justice? Not your lordships, their lordships in the Honorable Supreme Court, not, there was a 1996 judgment of our division bench as well, but in the matter of a suit, where the injunction order was violated, in contempt, the matter ultimately went up to the Honorable Division Bench, in contempt from the civil court. Now, the court held that to render retributive justice, the court in contempt jurisdiction can also pass injunction order. Now, that's why not the sanctity of not what I am supposed to do as a petitioner in a contempt application. I only bring facts to your lordship's kind notice. And what the purpose of contempt is not only to protect the order, but also to protect what is more important is the administration of justice. Not if the order of this BLN and LRO is allowed to stand or not set at rest, then not administration of justice not suffers at the hand of this authority. And not the paramount supremacy of this honorable court in exercise of high prerogative jurisdiction of this honorable court is undermined blatantly by the instance of this, at the instance of this administrative authority. Now, I have two judgments to cite. One is 2011 6 SCC 385. This is on the point of overreaching court's order. That's also contempt. Now, the relevant paragraphs would be 8, 9, and 10. Paragraph 8.
Yes.
In this case, the order of this court dated 6th October 2010 has been totally flouted. It appears that the alleged subtenant in the execution proceedings raised an objection which was rejected on 1/4/2011, against which an appeal was filed to the additional district judge Archana Sinha, who by a detailed order has granted stay of the warrant of possession. It seems to us that in this country, certain members of the subordinate courts do not even care for the orders of this court. When this court had passed an order granting 6 months' time to vacate, the contemner had no business to pass the order, but instead she has stayed the warrants of possession, meaning thereby that she has practically superseded our order and overruled us. We are constrained to say that a certain section of the subordinate judiciary in this country is bringing the whole judiciary of India into disrepute by passing orders on extraneous considerations. We do not wish to comment on the various allegations which are often made to us about what certain members of the subordinate judiciary are doing, but we do want to say that these kinds of malpractices have to be totally weeded out. Such subordinate judiciary judges are bringing a bad name to the whole institution and must be thrown out of the. That is a scathing remark on the judiciary or the judge. I'm not on that, but not to say that the subordinate court or a subordinate authority was really sitting in appeal over the court's order itself is contempt, and that depends on the nature of order passed on remand. Please see note the other order. The power of the court to pass order for compliance. 2017 5 SCC 506. (17 5 506).
Paragraph.
But the paragraph is 23. At 516.
Yes.
As held by this court in DDA versus Keepers Construction, and going a step further, the court has a duty to issue appropriate directions for remedying or rectifying the things done in violation of the orders. In that regard, the court may even take restitutive measures at any stage of the proceedings. So that's the law. Enforcement through not only by punishing but also not directing the order to be the justice to be restituted by compliance, making compliance. But these are my submissions.
May it please your lordship. My lord, kindly take, my lord, the contempt petition my lord, the violation complained of, if your lordships will, my lord, look at, my lord, the cause title. Is, my lord, a simple statement of not complying. My lord, what, my lord, my lord, how, my lord, it is not complying, my lord, has not been indicated at all. That's the very important point, my lord, as far as, my lord, a contempt petition is concerned. Contempt petitions, yes, if there is an interim order or a final order, it's not complied with, my lord, then, my lord, a contempt will lie, provided, my lord, it's a willful and deliberate, my lord, non-compliance. And, my lord, it is explained, my lord, also that this is how it's not been complied with. Now, my lord, kindly have a look at, my lord, page 10 again. Lordship will find here, my lord, a particular page 10, my lord, the
Of the contempt.
contempt. My lord, the prayer portion here, my lord, now elaborates, my lord, how, my lord, this contempt, my lord, has occurred. Page 10.
Yes.
Why? For her willful and deliberate violation in not taking what? Appropriate steps to consider the representation submitted by the petitioner dated 31st January 2016 and the proposal of the Block Land and Land Reforms Officer dated 16 November 2017 and finalize such proposal in favor of the petitioner within 2 months from the date of communication of this order in terms of the proposal dated 16 November as specified in the order dated 9th March. So, my lord, it talks about, my lord, two, my lord, documents. One is, my lord, a representation submitted by the writ petitioner, 31st January 2016, and, my lord, a proposal, my lord, of, my lord, the land reforms officer of 16 November.
Finalization of the proposal.
Finalization. My lord, this is what is, yes, finalization of the proposal. Now, my lord, a finalization of the proposal, my lord, if, my lord, the matter is being remitted, my lord, to, my lord, the authorities to decide on it, my lord, finally, my lord, that does not, my lord, there was no need, my lord, if the no discretion was being left to the authorities at all.
That's exactly the case here. No discretion was left to the authorities at all.
Oh, that's my lord, because my
The
respect for,
order says so.
no, my lord, we've read it, my lord, differently, my lord, and I'll tell your lordships why. Because, my lord, if your lordships, my lord, look at, my lord, because, my lord, that is, there was no need to remand it back then. There's no need to. Court should have said, that's it. It's finalized, it's done.
The court has said so. For
No.
finalization.
No, no. Court should have decided, finished it then and there. There was no need to send it back.
That's the court's discretion, is it?
No. My lord, if it's, my lord, being sent back to take a decision, then the decision-making authority should have the right to make the decision.
Please come to the language of the
Yes, my
order.
lord, kindly come, my lord, to the, my lord, language, my lord, of, my lord, the order. My lord, 9th of March, my lord, kindly take, my lord, the 9th of March order. Yes, page 85, my lord. Kindly, my lord, take, my lord, the 9th of March order, my lord. Kindly, my lord, have a look at this and kindly have a look at the writ petition prayers also. My lord, page 30, because, my lord, your lordships, my lord, were considering this.
Page 30 of the contempt application.
Yes, my lord, it starts, my lord, at page 29, the prayers. Page 29, my lord, of the contempt. My lord, it's an annexure, my lord, to the contempt petition.
Page 29 is a judgment. I'll just find out from the writ petition.
Of the contempt application, my lord. Page 29 of the contempt is they've annexed it.
Page 29 is a judgment, not
Oh.
the.
Page 30 of the contempt application.
I'll go through the video. Yes, the order.
Yes, my lord. Kindly see prayer A at 29, it starts, my lord. Then, my lord, kindly come to prayer B. Review to baat kore rakhunga. A writ in the nature of mandamus, commanding the respondents to finalize the application of the petitioner. So, my lord, it's the application of the petitioner for long-term settlement dated 31st January 2016 being annexure P3 by settling the land in favor of the petitioner. So my lord, finalize the application of the petitioner by settling the land in favor of the petitioner forthwith and within a time to be fixed by this honorable court.
Yes.
So it's to act on an application by the petitioner, and how to act by settling it in favor. Now, my lord, kindly come to, my lord, the order, my lord, which has been passed by your lordships. My lord, 9th of March, 2022.
Yes.
The petitioner prays for an early disposal of the representation submitted by him on 31st January 2016 before the Principal Secretary, Land and Land Reforms Officer. Learned Counsel for the petitioner submits that the petitioner was granted lease in respect of the plot in question by virtue of a deed of lease executed on 25th September 2013 by the erstwhile lessees and is in possession of the plot since then. It was subsequently observed by the Block Land and Land Reforms Officer Faridpur Durgapur that the erstwhile lessees had no right to execute the sublease in favor of the petitioner and have therefore lost their right, title and possession over the plot in question. The authority further observed that long-term settlement would be granted in favor of the petitioner, and such proposal was forwarded to the additional district magistrate and district land and land reforms officer by the Block Land and Land Reforms Officer by a letter dated 16 November. Petitioner submits that the said proposal has not been finalized till date. It is submitted on behalf of the state respondents that the second respondent be directed to consider the proposal. My lord, this is the statement. Yes, my lord. Made in favor of the petitioner by the Block and Land Reforms Officer within a stipulated time frame. Upon consideration of the submissions made on behalf of the parties, as well as material on record, the writ petition is disposed of, directing the second respondent to consider the representation submitted by the petitioner dated so and so, and the proposal of the Land and Land Reforms Officer dated 16 November 2017, and finalize such proposal in favor of the petitioner within 2 months from date of communication of this order in terms of the proposal dated 16 November 2017. With the above observations, whence. Now, my lord, the state, my lord, read it as, my lord, and I'm, my lord, making it very clear here, that, my lord, the additional district magistrate and district land and land reforms officer will, my lord, consider this proposal and finalize it. Yes. So finalization can mean rejection as well. My lord, it's a termination, my lord, of, my lord, consideration of the proposal.
Finalize it in favor of the petitioner.
Correct. But, my lord, it doesn't talk about settlement, which was there, my lord, in the prayer, in the writ petition, to settle the land in favor of the petitioner. So a finalization order, my lord, disposes of, my lord, the application made, my lord, by the petitioner. Because the law here is well settled. And, my lord, we have a division bench as well, that, my lord, the entire matter has to initiate, my lord, from the state. My lord, nobody can come, my lord, and ask for a settlement, my lord, in their favor. Nobody can come. My lord, I have a division bench judgment, my lord, on that.
I'm afraid you're on merits of the writ petition, which is not permissible.
No, I'm not. No, but my lord, these are matters which, my lord, they consider, my lord, when reading. My lord, this is how, my lord, I am, all that I'm trying to tell your lordship, my lord, is that there has not been, my lord, your lordships might feel, my lord, that the order required, my lord, gave no discretion. This is how it was. My lord, yes, this is what your lordship's feeling. My lord, the state, my lord, bona fide, my lord, took a stand, felt that, my lord, they were to, my lord, they had a discretion left in the matter. A final disposal, my lord, would mean, my lord, that they would consider it in accordance with law and deal with it. That's what they've done. My lord, there was no intention, my lord, to violate. That's all. My lord, I'm facing a contempt. I'm not going to now, my lord, challenge your order before your lordship. I am saying, my lord, that this is the interpretation, my lord, which had been put, my lord, by the state authorities. My lord, if your lordships feel, my lord, that my lord, if it's, my lord, capable of more than one interpretation, contempt will not lie. If your lordship feels, my lord, that no, this is not, my lord, right, then your lordships will issue a rule.
Have to.
Yes.
Because there is no question of an interpretation of this order.
Then, my lord, that's all that I'm saying, my lord. All that I'm saying. My lord, we have to then, my lord, know, my lord, that this was what was actually meant. we'll, my lord, answer the rule.
I can at best give you another month's time to comply with the order.
Hmm?
To avoid issuance of rule.
দেখো কি এগুলো তো সব যায়নি। No, no, we should have done it before. My lord, I'll have to, my lord, sit with them, my lord, and my lord, find out, my lord. Kindly give me, my lord, till tomorrow, my lord. On Monday, I'll come and indicate.
Little more time,
Yes.
please take instructions and. come.
Yes, my lord, I'll. Because, my lord, when, my lord,
I have expressed my mind.
correct,
So,
my lord, I have to react, my lord, to what, my lord, the court is saying. My lord, I cannot.
Scope of discretion in this order. The order has.
No,
not
no,
been
so your
carried out.
lordships, my lord, as I understand it now, your lordships wanted, my lord, that the settlement should be done. The, my lord, competent officer should, my lord, execute the long-term settlement in favor of, my lord.
Finalized in terms of the proposal already given by the state itself. The proposal.
My
was
lord, that's
given by the state.
interdepartmental. That's interdepartmental. It's not a decision of the state. My lord, it's not a decision of the
The
state.
state.
No, it's not a decision of the state. My lord, it's in the hierarchy. The document itself, but my lord, I'm not getting into it. Your lordships, my lord.
Carry the judgment in appeal. That has not been done.
My lord, I am told, my lord, an appeal has been filed.
Yes,
Just couple of days,
yes,
just 2 days back.
just 2 days back.
We are being very candid to you.
Appeal has been filed. I've just been told, my lord, which is why when your lordship said come back after a month, my lord, I wanted to ascertain, my lord, whether appeal had been filed or not.
If you can give the number, if there's a stay, I'll.
No, it's just been filed, my lord, so it'll,
I'll give you a little more time for instructions in that case.
very well.
I do not want a conflict of decisions to happen. So
No,
if
no,
the
no.
Appeal is taken up, then
Yeah, yes.
let's see. Yes, Mr. Majumdar. Let some time be granted for taking instructions.
Yes, no, next week, no. So comments. But he's,
কোথায় ছাড়বে?
my learned advocate general submitted that he would sit with his client tomorrow. So but next week would be fair enough.
না, না, সেটা ঠিক, না।
There's another submission of an appeal. So.
No, no, that is not, that can be taken care of, not here and now.
Heard learned counsels for the parties. Paragraph. Learned counsel, learned advocate general seeks accommodation to take further instructions in the matter. Stop. It is also submitted that an appeal has been preferred against the order under contempt. Paragraph. Let the matter appear under the same heading on 12th September should be
Very
sufficient.
well. I'm grateful. My lord, could it be 11th, my lord?
Very well.
Oh, bless.
11th September.
Oh.
Yes.
My lord, I'm told the Supreme Court summoned me, my lord, for this.
When do you want to come?
My lord, I can keep it any day after the 12th, any day.
After 12th? 14th?
Oh, bless.
12.
I am for the petitioner, my lord. My contempt application, my lord.
Is it appearing for the first time?
No, my lord.
My lord, only
Several
thing, my
times,
lord, my lord, only
kindly
thing,
see,
my
my
lord, let us not, my lord, go into that aspect, my lord.
Which
I am begging one indulgence.
Oh, my lord. No,
My
my
lord,
lord.
give me
No, my lord.
1 month's time,
No.
so that if it is
No,
not,
my
my lord,
No, my
can
lord.
I?
My lord.
I am.
The appeal was preferred, appeal was dismissed.
My
My
lord,
lord, kindly see.
my lord, kindly, my lord, SLP is going, my lord, only thing, my lord, kindly give us.
Submit any slip of
Oof,
paper, my lord.
my
they
lord,
have filed appeal,
kindly,
my lord.
kindly,
Order was passed, appeal was dismissed on my lord,
Oof,
19th.
my
July,
lord, kindly see the
23.
appeal
This is
court
the order.
judgment.
No.
There is a wrong quoting of the section, wrong
No,
facts.
I am,
My lord, I am not on that.
original order was
My lord,
passed. on
I am not on that. My lord, only thing, my lord, I am begging one indulgence for that. My lord, I am seeking that.
No.
My lord, only thing.
Because show cause has to be
No, my lord,
No.
15 days time.
No, my lord, July, my lord, order was passed on July,
Just a
19 July.
15 days for the show cause as to why rule shall
Yes.
not be issued.
Yes,
Yes,
my
yes,
lord.
15.
Yes.
Yes, yes. No, instead of 15 days, 21 days.
No,
No,
not at
no.
all.
21 days because in the
7
meantime,
days.
7 days, yes, 7.
No, 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 15 days. 15 days.
Learned counsel for the alleged contemner submits that a special leave petition as intended has not been filed as yet.
Yes, yes.
Paragraph. The alleged contemner is directed to show cause within 15 days from date as to why rule of contempt shall not be issued against him for deliberate non-compliance of the order under contempt. Paragraph. Let the matter appear under the same heading on
17th or 18th.
You've forgotten count of 15, Mr. Sengupta.
Well, 17th. Well, I am
September.
11th September.
Deeply applied.
Paragraph, the department is directed to.
No, Malad, so cause Malad is not required. So cause. Obliged. Well, I'm sorry, Malad. Taking.
Personally appear before this court and file and show cause. The alleged contemner is directed to personally appear before this court and show cause. First line.
Malad, 15 days, Malad, because my lord has did not issue rule.
So what?
Because
You come and
after
come and
15 days,
explain.
Malad, Mr. Malad, only thing. So
Sufficient
personal appearance, Malad, kindly.
Yes,
If
of
they, if 2 weeks, but personal appearance, my lord, yes, my lord has every right. Malad, only that portion.
Let him
Malad,
come.
15 days. Malad, 15 days. I am.
It's a show cause. It has
Malad,
to
I
be
show cause.
within 15 days.
I will give the reply against the show cause. Malad, I will. But Malad, personal appearance.
He
Malad,
has
I
to
am.
come before
Because
the court.
unless rule be issued, Malad knows that. Malad, kindly. Because my lords, Malad, yes, Malad gave the, Malad, only I am praying that. Only I am praying that, Malad. Only
Item 13.
personal appearance.
No, not at all.
15 days, Malad, I will come with that application.
He'll come back.
It is-
He'll come before the court after 15 days and explain.
Explain, Malad. And Malad, only thing, Malad, that rule, Malad, my lord, why the rule will not be issued, my lord? My lord has made that observation. Malad,
Because
only.
it's always on a
I'm-
personal appearance.
I am
decision.
praying.
So no,
Malad, I am praying. Last.
last and all is over. No.
Last chance is
Next
not-
matter.
Malad, last chance.
Next.
Malad, only thing, Malad, I am praying that.
13.
512. Next matter.
My lord, in
Right.
this matter, I am appearing on behalf of the writ petitioner applicant, my lord. On earlier occasion, your lordships has been pleased to pass and direct to issue the notice upon the
Yes.
alleged contemner, my lord. My lord, this is kindly, my lord, kindly come to the order, my lord, earlier order on 27/7/2023.
There's a report from the department. Give me a minute, please. Ramakrishna Ghosh is the alleged contemner.
Yes, my lord.
It is yet to be delivered. It has not been served.
My lord, kindly consider it. It was 1 month ago, order has been passed by your lordships.
Department's report, it has not been served, so cannot be done. It has another day.
My lord, kindly fixed a short date, otherwise my clients will suffer, my lord. They take my land forcefully, despite your lordship's restraining order, they constructed the road.
It appears from the report submitted by the department that notice of show cause is yet to be, a notice of show cause as directed by the order passed on 27th July 2023 is yet to be served. Paragraph. Let the matter appear under the same heading on 13th September.
My lord, kindly short date,
Paragraph-
otherwise it will
It
take,
has to be served, sir. Please understand.
it will take only 2
The-
days, my lord. Kindly consider, we are serving
It has taken 1 month. The department has to serve, not you.
as your lordship.
The department is directed to serve a fresh notice upon the alleged contemner in terms of the order passed on 27th July 2023 and submit a report on the adjourned date. Immediately নিচে নামো। অর্ডারের পরে ইমিডিয়েটলি নামিয়ে দেবো। 13 একদম শুরুতে লিখুন ওটা personally appear before this court and show cause একদম শুরুতে ফার্স্ট লাইনটা কি লিখেছেন তারপরে এই যে directed to personally appear before this court and show cause হ্যাঁ তাই তো করবেন personally appear before this court and show cause next
14.
14. Sorry, Dada, 14.
Lordship,
yes
I am praying for not to the Lordship on behalf of learned advocate Mr. Prosenjit Mukherjee appearing for the petition.
I have already submitted.
affidavit of compliance submitted on behalf of the alleged compliant.
Yes.
Submitted on behalf of the alleged contemner is taken on record. Paragraph on prayer of the petition, on prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14 September.
I am for the petitioner, my lord. Lordship's order dated 12th May.
Is it appearing for the first time?
Yes.
Will you serve and come back?
Sir, already you have served.
Served.
Yes.
If you said first time,
First time.
Contempt petition served.
No, contempt has not been served.
yes, you have to serve and come back. The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 14 September.
You do.
16.
My lord, I am for the applicant. First time, my lord, appearing.
Yes, first
First
time,
time.
serve and come back,
My lord,
14 September.
my lord, one more indulgence I am praying. I have written the name of the alleged contemner in the cause title, but in the prayer portion I have missed it. My lord, kindly
Want
repeat
to
it.
make a correction?
My lord.
Service আগে একটা ইয়ে করুন on prayer of the applicant petitioner. Liberty is granted to correct the prayer of the contempt application. তারপরে service direction.
Date.
Please
Let
make the
date.
correction. Yes.
Date.
14 September.
Let's shoot it.
17.
Petition. My lord, the petitioners, 6 of them, my lord, they are street vendors, my lord, as per the definition of this act, my lord. My lord, amongst, my lord, 400 others, they are operating, my lord, they are vending in this area which is known as, my lord, Raidhigi Bazaar, my lord, to both sides of the road. My lord, on one writ petition was filed by one Dilip Kumar Haldar, my lord, WPA 5652. And in that case, my lord, with a order dated 20th of March 2019, the Honorable Justice Devanshu Boshak, my lord, directed the respondent BL and LRO to visit the local and take steps under the West Bengal Highways Act. My lord, we were neither the parties in the writ petition or in the contempt petition, my lord, arising out of the writ petition. My lord, even then, my lord, eviction notice was issued, my lord, by the assistant engineer PWT. My lord, that eviction notice was set aside by the Honorable Justice, my lord, Shobhoshachi Bhattacharya. My lord, the order is at, your lordship may kindly finds at 69. My lord, subsequently,
69 was issued against you.
69, my lord, the order dated at page 69, my lord.
Yes.
My lord, that was an, my lord, purported eviction notice without addressing anybody. It was affixed in some shops. My lord, after that eviction notice was, my lord, quashed and set aside, my lord, the assistant engineer now, my lord, issues this impugned notice, my lord, if your lordship may kindly finds at page number 57. My lord, this is addressed to us, my lord, saying that, or my lord, calling upon us to remove encroachments. My lord, the reference has been made to the, my lord, CPAN that was arising out of the writ petition. We were not parties.
Notice has been issued under the 2014 Act.
My lord, the 1964 Act, my lord. Highways Act. My lord, our prayer is, my lord, after receipt of this notice, my lord, we have submitted an application under section 8(2) of the Act of 1964.
For regularization.
For, my lord, granting of permit, your lordship knows, because, my lord, we have been favored by an order by your lordship in
Where
an
is the
earlier
notice?
writ petition.
Where is the notice?
My lord, page 63, my lord. 59, I'm sorry. Page 59. 59, my lord, is the our prayer for permit under section 8(2).
Yes.
And, my lord, kindly sees your lordship's order, my lord, at page 63, in an earlier writ petition by, my lord, two of the adjacent shop owners. And your lordship was pleased to, my lord, direct the assistant engineer or the highway authority to concert the,
Section 8 notice has been issued.
my lord, 6 and 10. Notice under section 6 and 10, our prayer was made under section 8, subsection 2. My lord, kindly sees the notice, my lord, they have indicated the sections. My lord, this is the Highways Act, if your lordship may kindly consider.
Where is the notice?
My lord, the impugn notice at page 57, my lord.
This is a 10(1) notice issued.
10(1) notice, my lord, read with section 6. And our prayer, my lord, is at page 59. My lord, another aspect, my lord, after your lordship directed them to consider the 8(2) application in respect of the other shop owners, my lord, they considered and they found that they are not encroachers at all. My lord, that order I have also annexed. My lord, at page 69, my lord. My lord, my only prayer is, my lord, kindly directs them to consider my prayer for permit and then, my lord, proceed with 10(1) or section 10 of the Act.
Yes, my lord. Your lordship passed. Yes.
I'm grateful, my lord. And also, my lord, may I, my lord, reply to an RTI application has been received yesterday saying, my lord,
Not necessary.
my lord, I'm grateful. Jana.
The notice issued under section 10(1) of the West Bengal Highways Act 1964 upon the petitioners is assailed in the writ petition. Paragraph, it is contended on behalf of the petitioners that the petitioners are street vendors / hawkers who run their temporary shops in the land adjacent to the Purbo Bishnupur Raidighi Road.
My lord,
Vishnupur.
both sides of that road.
Purbo Bishnupur - Raidighi Road at Raidighi Bazaar for the last 40 years. Stop. "40 years and cannot be termed as encroachers on PWD road." Stop. The petitioners submitted an application under section 8 within bracket 2 of the West Bengal Highways Act 1964 before the concerned authority for permission to use / occupy the plot in question and issuance of patta in
My
their
lord,
favor.
also, yes.
And issuance of patta in their favor. এটা ডেটটা দিন 8(2) বললাম না, on 21st August 20 application under section 8 on 21st August 2023. Stop. The said application is yet to be, application is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the said application before proceeding with the process under section 10(2) of the Act of 1964.
Executive magistrate
Paragraph. It is submitted on behalf of the respondents that the assistant engineer will consider that the fourth respondent be directed to consider the application submitted by the petitioners in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the application submitted by the petitioners dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested.
I appear for the respondent numbers 4 to 12.
My lord, I am appearing for the respondent number
petitioner,
3.
Lord.
My lord, I am praying for not today, my lord.
Why?
My lord, matter has come up suddenly and we could not inform the
My lord, if
councils.
your lordship recalls, my lord, we have served initially twice. My lord, they did not appear, my lord. Then we gave them a notice, my lord, pursuant to your lordship, and Mr. Kishore Dotto had mentioned this matter, my lord. If my lord, she has, my lord, told Mr. Dotto as well, my lord, they will be going. If your lordship, my lord, kindly fix it then Monday only, because we are suffering. There is an, my lord, we have been mentioning it for a long time, my lord, and if, yes, it mentioned,
State, Mr. Police.
my lord, in that case, my lord,
You are for
but for the private respondents, my lord, 4
all
to
of
12.
them? 4 to 12.
4 to 12.
Who is appearing for the Indian Oil?
I am appearing for the Indian Oil Corporation, respondent number 3, my lord.
They are the answering respondents, my lord.
They are the answering respondents.
My lord, I am only praying for not today, my lord.
Where will not today?
Very well. My lord, let it retain its position, my lord, in the list.
I hope it will.
Fine.
New matter.
Great.
Not
19, I am appearing on behalf of the respondent number 123, your lordship.
petition.
I'm for the petitioner, lordship.
Lord, Advocate Bojesh is appearing for Indian of India. However, is in this post, my lord. My lord, may the matter may be taken on next week.
Railways, you are appearing.
Yes, senior counsel is Bojesh.
Yes.
Senior counsel is Bojesh.
Come back some other day. London Council is
Lordship.
not there. You are for the Union of India. On prayer of the Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
15th,
1-5.
lordship.
Lordship.
I beg to appear on behalf of the petitioner.
Now the state.
Well, this matter, my lord, what happened, my lord? Petitioner is a owner of a 12 decimals of land. Now, lord, one of the private respondent filed a writ application before your lordship, directing that some encroachment is there. Accordingly, your lordship directed to dispose of his presentation. Your lordship's order is at page 22.
There is a private respondent also in this matter.
Yes, yes.
Who is appearing?
No, he appeared several occasions. He appeared. He filed report.
Give me a minute, please.
Interim order initially issued by your lordship, thereafter time to time extended.
For the respondent number 11.
Respondent number?
11.
11. The others are state respondents. is it?
Yes, yes, ma'am.
Yes.
On the basis of this order, my lord, the proceeding was started. I 10-2 proceedings thereafter 10-4 I preferred an appeal. My lord, this is the order of 10-4 is at page, it starts from order starts from page 32. 32 to 30. 31, my lord. The relevant observation is at page 36.
Yes.
Yes, kindly see, my lord. In this connection, Blockland and Enabler Officer Raninagar to block Murshidabad inquiry into the matter and submitted the joint demarcation report pertaining to such and such Mauja and in presence of the petitioner, such and such. Here, my lord, one thing, my lord, the notice was issued to the husband of the petitioner, although the petitioner is the owner of the land. Thereafter, decision with reason, if you will kindly take table to look at decision with reason at page 37. Last paragraph.
The petitioner was present when the hearing was made.
This is the petitioner was made husband. Not Ajima Bibi is the petition.
During the 10-4 hearing, petition. it is a
10-4
petitioner's
testified.
appeal.
Petitioners.
So the question of notice doesn't arise.
Ajima করেছে তো? No,
Petitioner's
yes, yes, my lord. Appeal was filed by the petitioner. Initial notice was served about the husband of the petitioner.
Appeal was filed by the.
By the petitioner, yes, my lord. Yes.
Notice doesn't.
No,
arise.
no, my lord. No.
Yes.
Now, my lord, page 37, the decision with reason.
Yes.
It says kindly see, my lord, page 38. Only, my lord, the report of the officers was taken into consideration. Petitioner case was not considered. Now, my lord, your lordship directed to call for the affidavit. Report. Your lordship directed the state respondents to file a report. এই তো report দিয়েছি।
My lord, I'm seeking, my lord, time, my lord, the report is not with my file. দিয়ে দাও আমাদের পরের দিন দেখে নি, আমার কাছে ফাইলেই নেই।
ও তাহলে কি report exception সব দেবে?
হ্যাঁ দিতে হবে, কিছুই নেই, এই যে এক্সেপশনটা আছে
অনেকগুলো আছে কিন্তু report reply exception
আমার কাছে যেটা
Private respondent.
নেই, এটা আমার কাছে কাগজ নেই।
Particular matter may not.
Was that your instance that the proceeding was initiated?
My instant proceeding on issue. And there is an admission that this land is vested by them. They have admitted that.
Super.
Where is the admission?
They are in, the documents, those have been given in the form of.
ওটা দিয়ে দাও, পরের দিন দেখে আমরা ইনস্ট্রাকশন নিয়ে নাও।
Here we are.
My lord.
Many stories are fabricated in order to.
No, I think 32 decimals, 22 decimals have been acquired. Oh, you said 32?
Yes. But I will report shows everything. Well, let the matter come. I will show your report says everything.
I look at this bed at the shop. Concerning the same property.
Printed copy, plain print.
Fourth page. Fourth page, that is paragraph 4th page, paragraph 4. Slightly down the middle.
32 decimals, yes. That is your case.
My lord.
32 decimals
lord.
acquired.
My lord, kindly,
There is a suit pending.
My lord, I have to take the instruction regarding this.
Your suit. You are the plaintiff.
My lord, I have to take instruction regarding suit, my lord.
You are for Ajima Bibi?
Yes, my lord. I have to take instruction what about the plaintiff is written. My lord, this my landed senior, my lord, kindly give me to take instruction regarding the plaint. What about plaint? I will come.
Can you please submit this on the next petition by way of an affidavit?
Yes. সেখানে বলেছে প্লেন্ট
Let me see.
আগে দেখতে দেন
It's a reasoned order. You were heard by the authorities. I do not know why.
No, no, my lord, I will show your lordship. Kindly see the report, your lordship.
Not report. The order says that the authority has heard you.
No, no, my lord, kindly see, your lordship will kindly, I will show your lordship, will satisfy that this is the request. If my learned senior friend allow me, otherwise not. I will show your lordship that it is not acquisition, it's a requisition under Defense of India Act. This is the admission, and in the Defense of India Act, the requisition is done for Pacific Pure for 6 months. My land was not acquired, I will file separate suit.
I am afraid the title suit says otherwise. So please take.
My lord, can I take instruction?
Take instructions.
Yes,
to
my
submit.
lord. On the
Submit the document by way of an affidavit. Yes.
and my lord, let copy to আমাদের সুটে ওরা কেন কপি করবে না কিন্তু কপিটা স্যার
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th August, because the interim order expires on 31st. 30th August. 30th, 30.
মানে ডিরেক্টলি তুমি সার্ভার কপি মানে
Copy of?
what you submit.
Whatever you file, please serve a copy to the others.
21.
কপি জেরক্স করে সাইডে দিন
It is your title
রিপোর্টের
suit,
তো
sir. Why do you want a copy?
রিপোর্টের একটা কপি
21.
আমি করে তোমাকে করে দিচ্ছি জেরক্স
In item number 21, I am for the petitioner, my lord.
Yes.
In this matter,
Junior friend submits. On the last occasion, your lordship directed and the left out person who was to meet the concerned officer, but my instruction is that they have not gone on the specific date fixed by your lordship.
yes, my lord, my
Even till
submission,
date.
my lord, my submission is the petitioners thought that they will serve a notice to appear in the hearing. That's a mistake on the part of the, no notice, but it was their impression that authority will serve a notice. Kindly give another date. On that day, they will come. Out of 15 petitioner, 11 petitioner has already got their compensation. Only 4 are left because of some error in the name of the father's name. And
Yes.
kindly fix
Your lordship,
another date.
I have got the another report also of your lordship, so desires I just hand over.
Ganguly, let the petitioners go before the authority.
Yes, my lord.
I do not have any objection.
Another date,
Yes, yes, they can go.
No notice will be served. Let
Yes,
me-
my lord.
No
That's
notice.
our
Your
own
lordship also
impression.
directed that no
Wrong
notice and in front of the learned.
I'm giving you
Yes,
date
my lord.
and
Yes, my lord. That's
Yes,
a
we
mistake
will
on the
give
part of
another.
the petitioner. I admit it.
instruct your clients.
Yes, my
accordingly.
lord.
Toরা গেলি না কেন?
Paragraph, it is submitted on behalf of the petitioners that 4
Well,
petitioners
just-
were unable to appear before the concerned authority on the date fixed, comma, that is 20th July 2023. And seek a further date so that they are able to appear before the authority. And seek a further date, bole stop karo. Seek a further date of hearing.
Only the left out person.
Paragraph, yes.
The left out person.
Left out, four.
139 and 139 and 10.
Yes.
Yes, yes.
4 petitioners bolam na, being petitioner numbers,
139 and 10.
first line. 4 petitioners, being petitioner numbers 1, 3, 9 and 10. Paragraph, in view of the above, comma, the said petitioners are directed to appear before the authority on, when can you appear?
Any day, next month.
Next
my lord.
week?
Next week. my lord.
Next month বলছিস তো।
ঠিক আছে, next week. My lord,
First September
1st September. my lord. 1st September.
at on 1st September.
ওরা কোথা থেকে আসে? দূর
When
থেকে?
can you?
They come from
11 o'clock?
11. My lord, kindly fix it at 12 o'clock.
12.
What he has told, Lord, they are coming from the villages.
Villages. my
So
lord.
2 p.m.
2 p.m. my lord.
Because they have to return
Yes,
again.
yes.
2 should be very late because they'll return again to the village. Let it be 12.
12, let it be
Early
12.
morning
man.
is
Yes,
difficult for village people.
yes.
They are coming perhaps,
Yes, yes.
coming
They
from
again
Nadia.
they have to
Coming
go
from
to-
Nadia.
No. South Church.
South Church.
So 12
12
noon. At 12 noon, in terms of the order passed on 11th July 2023. Paragraph, let the matter appear under the same heading on 8th September.
8 September.
The matter will appear on 8th September.
22.
Grateful.
I appear for the KMD.
Petitioner.
Yes, ma'am. So I made a representation. The KMDA, my plot of land has been acquired. But I have not been paid the compensation. Not the plot of land has been utilized for the purpose of acquisition. Which acquisition was acquired, land was acquired. I made a representation on page 34. Let them decide it, man, in a particular time.
34.
34.
Understand? Yes. WP number? WP number? WP number? What was that? 5628. Oh.
Yes.
Page 34, my lord.
KMD is not the authority to decide compensation. It is the acquiring authority who can decide. Where the requiring body.
The government has to decide.
Government has to decide.
Special land acquisition officer.
And special land acquisition officer.
Respondent of 5 may be directed, my lord, your lordship kindly.
5. 5 is the land acquisition collector.
Assistant land acquisition officer, 5 and 6.
It should be decided by the special land acquisition. Include him as a party. I'll grant you liberty. অর্ডারের নামটা ভুল আছে, এটা লিখবেন না কিন্তু তিথি পাল নাম গৌরী গুহ কাছে বেরিয়ে গেছে, যাক এইটা দেখে নিয়ে লিখবেন, ওইটা দেখে কপি করবেন না, তাহলে ভুল হয়েছে। না না সে বলছি না না অনেক সময় আগের অর্ডার শিট দেখে নামটা করেন।
My lord, so far this plot of land is concerned, as mentioned in the representation, my lord, perhaps we are not the requiring body in respect of this particular plot.
State consider
They have acquired, let them either they have to return back or to
on
pay.
prayer of the petitioner, liberty is granted to implead the special land acquisition officer,
Maybe some other authority.
South 24 Parganas, as respondent number 7 in the writ petition. Stop, the cause title of the writ petition be amended accordingly. Paragraph, the petitioner claims to be the recorded owner of the plots in question and submits that the plot was, that though the plot was acquired, though the plots were acquired by the state respondents, comma, no compensation has been paid to the petitioner for the same, comma, nor have the plots been utilized by the authority. Stop. The petitioner submitted a representation before the concerned authority on 24th January 2023. Ventilating her grievance.
Whether at
Which is
this,
yet to be,
at this belated, it's an acquisition of 1976, 77. In 2023, he is coming up with the representation.
which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the 7th respondent be directed to consider the representation at the earliest. Paragraph, in view of the above, the writ petition is disposed of, directing the 7th respondent to consider and dispose of the representation.
Yes, to this,
File a separate application.
yes, because this is addressed to KMD.
Has filed na kore, the petitioner seeks to, the petition, ওই লাইনটা কেটে দিন, has filed যেটা, has not been considered as yet.
Second respondent.
ওই এর পরে, not utilized.
7 to 9. 7 to 9.
হ্যাঁ, তারপরে। The petitioner seeks to submit a comprehensive representation before the concerned authority ventilating her grievance and prays for a direction upon the authority to consider the representation at the earliest. It is submitted on paragraph, it is submitted, seventh respondent shall consider. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the seventh respondent within 15 days. Within 15 days from date. Stop. The seventh respondent is directed to consider and dispose of the representation within 1 month. Within 2 months from the date of communication of this order, from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Well, since we have not used any report or opposition, contents are not.
They are the usual lines which are recorded. Since no affidavit.
One line, because.
They are recorded in every order.
Other-
They are the usual lines.
Usual.
Unless it is a hearing matter on. affidavit.
Sometimes it goes against us if it is not there.
No. It will be recorded.
The next matter is also by the same petitioner. No,
Same petition.
this particular plot is fully acquired by KMDA long back in 1968-69.
এটা তুমি বলছো কিন্তু দিলীপ দা বলেছে কথা পিটিশনার বলেনি
দিলীপ দা তো আর বলবে কি?
বলেনি
দিলীপ দা তো
জানে না দিলীপ দা
Yes, Mr. Bandhavada?
this also
the petition of statesman lord his land has been acquired.
Yes.
He has not mentioned in which year, in which case number, nothing has been then mentioned, my lord, in the representation or in the spirit petition.
it's a vague.
Vague allegation.
Vague. Page 22. This is also addressed to KMD.
He'll file a fresh representation.
Yes. Mentioning the my case
All the
number.
details.
Only my lord,
How
I
can
am
he
coming
know?
before the court, my land has been
How can I know?
acquired.
How can I know?
তা আমরা যে বলে দেবেন আমরা জমি ভেস্টেড হয়ে গেল
তুমি নিয়ে চলে যাবে?
সে বলেছে নিয়ে গেছে আপনার it is
How
your
only?
mere apprehension.
My apprehension, I have lost my ownership, I have lost my possession, and you are saying all these things.
KMD is the authority.
You should come within time.
How is it that you are not aware of the LA case number?
Malad, your logic can see. Under the land action, there is no provision of delay. Supreme Court made it clear.
No.
There is no question of delay
Yes.
in land action matter.
Who says so?
My lord has.
This is their duty to make payment of matter. They have not done so.
No mention of who in which year, in which case number, which plot, nothing.
Please mention the
No, plot
details.
number I have mentioned.
Number বলেছে
Absolutely.
LA case.
আমি
you
যে
have
বললাম,
to-
absolutely.
It was acquired for the
He could have applied under the right to information act.
project matter.
বলে দিচ্ছ তুমি
Delta Mala, we
বলবে না তুমি অ্যাড্রেস করো
are too much to move.
This petitioner could have applied under the right to information act if he so desire.
No, he is asking for compensation only in this matter.
Only matter there.
Question of utilization is not there in this.
No.
It's only compensation. Let
Only
him file a
compensation.
representation, consider it. With that, sir. Please state the details of the case in the representation. Otherwise, it cannot be considered.
That much information do not have. I have to-
Because compensation is in connection with the
I
LA
can make
case.
comprehensive representation stating what we have.
Please do that.
Ashok, kindly record my submission that the land in question was acquired long back in 1968-16.
I'll record. The petitioner claims to be the recorded owner of the plot in question. Petitioners claim to be the recorded owners of the plot in question and submit that though the land was acquired by the state respondents, no compensation has been paid to the petitioners till date. Stop. You have a representative, you file a comprehensive representation.
No, you have to make a comprehensive.
Special land division officer. And
Yes, yes.
I shall make him party.
আগে করুন। On prayer of the petitioners, শুরুতে কিন্তু liberty is granted to implead the special land acquisition officer, South 24 Parganas, as respondent number 6 in the writ petition. The cause title of the writ petition be amended accordingly. তারপরে ওখানে the petitioners seek to ওটার পরে no compensation has been paid. That the petitioners seek to submit a comprehensive representation ventilating their grievance before the concerned authority and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the KMDA that the entire land was acquired by the respondents
long back in my lord 1968-69 in connection with LA case number
hyphen 69.
69
LA case number
4/6 of 1968.
4/6 of 1968-69.
Yes, yes.
Stop. Paragraph, be that as it may, comma, since the petitioners seek to submit a representation before the concerned authority, comma, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the sixth respondent within 15 days from date. Stop. Paragraph, the sixth respondent is directed to consider and dispose of the representation within 2 months. Within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof.
The same rider will also be there.
24.
I am appearing on behalf of the petitioner, my lord. I led by Susanto Rokhi,
Yes.
senior advocate. My lord, here, my lord, mining lease and minerals. Regarding my lord, who made an application and statutory format. Thereafter made a representation on page 29, 23.
For grant of long-term lease.
Mining lease, long-term mining lease of for sand. Representation, my lord, annexure, page 23, P3. Page 2019, my lord, application. 24, the representation. 18. Statutory application, thereafter, my lord, made a representation, several representation made. 20.
Page 19 initially has applied in the year 2014. Thereafter, my lord, on my page 23, that is, my lord, reminder of that application of page 19, my lord. Now the new act has come.
Considered in accordance with
New
law.
act has
In
come, my lord. How
accordance
it is
with-
possible? There is a provision of, my lord, deed, auction, my lord.
Yes. After 2014, you have not approached the authority at all.
Then, my lord,
It was
reject
only
my,
in 2023.
well, statutory authority reject my application, then you are not.
It is not rejected. You have not, you have approached only in 2023. The new rules came into force. It's the 2016 rules.
Then, my lord, it's not my matter, my lord,
Yes.
my lord, adjourn the matter, my lord, for 1 week.
Because this application will only terminate in rejection, that's all, isn't it? Due to advent of the 2016 rules.
23. Page 23, my lord, consider my application mining lease. Then, my lord, it is not the bar. Then, my lord, I again made an application or my lord, liberty to made an application in terms of the, I mean,
In terms of,
new
you
rules.
cannot make an application, it's an e-auction now.
Yes, sir.
You have to participate in the e-auction.
No.
In terms of the 2016 rules.
The rules to that. That is, my lord, kindly see my statutory application, my lord.
Yes.
That is the. My lord,
Your application is under the 2002 rules.
yes.
Now we have the 2016 rules.
আমি অত জানলে তো বলতাম আমরা, আমি কি জানি, আমাকে বললো, তুই তো আমাকে বোঝাচ্ছিস। There were some instructions, my lord. Mr. Rokit is here, my lord. I will give 1 week time.
Let it be adjourned because it cannot be entertained. There is no cause of action actually in at present in your petition. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
Affidavit service.
শুরুতে affidavit of service. Rajiv.
নামটা দেবেন নামটা দেবেন
25.
Yes.
Lordship, Mr. Siddiqui is appearing on behalf of the state in this matter. He is engaged in another courtroom, Lordship. I'm praying for
There
not
was
today,
a
Lordship.
prayer earlier, my lord, for accommodation. The previous time, the previous month, the matter appeared.
Yes.
There was reservice of copies again. I'm not on a very short point, my lord. Division bench of this honorable court has directed that my land which has been acquired, compensation be assessed and payment be made to me in accordance with the 2013 Act. That division bench's order is not under challenge. It has been accepted by the state. Now, pursuant or in purported pursuance of the division bench's order, an award has been made. Snippets of the award have been sent to me, as in sheets relevant to me have been sent to me under the RTI. The entirety has not been sent to me. On seeing the award, I have found that the award is manifestly perverse, as it doesn't take into consideration the various factors necessary under the 2013 Act. Guidelines as indicated by the Honorable Supreme Court read with the 2013 Act, including factors of solatium, interest, damages, and the like. Therefore, my lord, I filed applications under section 64 of the 2013 Act for a reference. This is akin to section 18 of the previous Act for a reference. Any person who has not accepted the award can seek that reference. Now, in answer to my applications for a reference, the authority has by the impugned communication said, you are not a person who's aggrieved by the award because you have accepted the awarded sum, and therefore no reference lies at your end. We have accepted the awarded sum in terms of interim orders made by the Honorable Single Judge and by the Honorable Division Bench.
That must have been after objection.
And it was accepted without prejudice to the rights and contentions of the parties in terms of specific orders made by court. That they are holding to be a disentitling factor for me to maintain my reference.
Come back some other day. Mr. Siddiqui is not there.
Lord, may I come back, Lord? If your lordship permits me, Lord, sometime very early next week. This matter has, Lord, the state, Lord, had been served once. They came up. He said he couldn't find his
Come
copy.
back on 6th.
6th of September. I'm deeply.
On prayer of the state respondents, the matter is urgent. Paragraph, let the matter appear under the same heading on 6th September.
Obliged, Lord.
My lord, I appear for the West Bengal Mineral Development and Trading Corporation, led by Mr. Shah.
Another matter, the lordship. On 9th of June, your lordship agreed to direct the another matter to be tagged, where iris of the notice inviting tender.
899 of 2023.
That is not appearing. That is to be tagged, that is to appear along with
Did
the.
you share it petitionটা? Order ছিল? Order sheet আছে? Let it come in that case. আগের দিনও তাই হয়েছিল। আগের দিনে একই অর্ডার হয়েছে, তার আগের দিনও বলা আছে। দুটো পর অর্ডারে বলা আছে।
My lord, may I file the report?
Report, yes, you can.
The report in the form of affidavit, my lord. On behalf
Report
of
in
the
the form of affidavit submitted on behalf of the WBMDTCL is taken on record. Have you received a copy, Mr. Sharma? Please serve him a copy.
My lord, I think they have been served, my lord.
Mr. Day is appearing for
Yes,
the
my lord,
state.
it has been served.
Paragraph WP 899 of 2023 is not with this file. Paragraph, the department is directed to put up the said petition along with this file on the adjourned date. Paragraph, let the matter appear under the same heading on 18th September. Mr. Chairman, 18th September. Let the file come.
Copy the okay. The copy which I have received according to him, my lord, is.
But there is his signature. my
No,
lord.
no, maybe. I have received at my cost. I shall be.
Please give him another
I
copy.
shall get his Xerox at my cost.
Yes,
27.
But I'm for the private respondent.
Private respondents?
Lordship, I'm for the
You're
private.
appearing? Petitioner?
Yes, my lord. If your lordship may kindly turn to page 85. The previous litigations, which is, brother?
84.
85, P10.
Yes. কোনটা ওইটা? তাহলে একসাথে রাখুন। দেখো ওটা নিয়ে, হ্যাঁ।
The middle portion, next page is the middle portion is the direction. In view of the above, the writ petition is disposed of, directing second respondent to consider the disposal of the representation dated such and such. In light of the observation made in the judgment passed on such and such entitled to number within a period of 2 months. So this was the direction passed by this honorable court. Now I can turn to the order impute, which is the subject matter of challenge before your lordship.
What was the judgment about? Was decreed in your favor?
Judgment is in my favor.
Restraint from interfering with the.
Yes. Now my lord can turn to page 88.
88.
Yes. Pursuant to my lord's direction, my lord, the authority concerned passed this judgment. Judgment or order. If your lordship can turn to page 89.
Yes.
Bill was restored to Ariskatin, Minimaskal Ariskatin, Jalkar Dong was not noted against the names of Dulal Chandra Ghosh and others and in different shares. My lord, findings, my lord, one, my lord got it.
Yes.
And thereafter the suit has been mentioned. Your lordship will find suit permanent injury, suit was decreed in favor of the plaintiff. Now, my lord, considering the same, my lord, the authority sits in the appeal, probably. If your lordship can turn to the ground of reaction for my application. That your lordship will find at page 91.
Yes.
Paragraph 3 onwards. In the instance there is no proof that after the declaration of the suit, landers tank fishery and after getting the status of proprietor, those intermediaries retain the subject land while in B form, therefore transferring the subject land to the writ petitioners. Therefore, the subject lands which are statutorily vested by the state by combined operational section 4 and 5 of the State Acquisition Act remain vested, not being retained, and the status of the writ petitioner post vested transferee. Well, this goes counter to the degree passed by the learned trial court. It is for the authority to decide whether, because this has been granted to be non-vested, it is declared to be the property belongs to the persons. And that suit was decreed sometimes in, my lord. Kindly turn to page 51. 2008. Page 51, your lordship will find. This is a judgment in appeal. The suit was decreed sometimes in 2008, and the state preferred the appeal.
That was dismissed, yes.
That was, which was been passed after considering the landmark judgment passed in the matter of Rothikantama, such and such, even assuming, though not by assumption, not my admission in any manner, assumption is not supported by law. The erstwhile proprietors got automatic retention to the subject tank fishery. But even then, the fact remains that the proprietors has alienated such tank fishery in 19 after the date of vesting of the West Bengal license, which is the opinion of the larger bench of the Honorable Supreme Court as well as the opinion of the Honorable Three Judges Bench of Calcutta is not permissible in the eye of law. And one, whether my lord was there for a moment, my lord, once, whether this authority has any jurisdiction under the law to interfere with the judgment, the state, whether this judgment binds the state or not. Even a wrong, my lord, I am, so for the judgment I will satisfy your lordship, that this honorable court said you cannot go into the merit. Either you challenge the same or you have to initiate fresh proceedings for reservation of the plot. Without doing the same, you cannot take usurp the jurisdiction of the civil court. Here, my lord, it is held that interpreting the judgment of referred to peculiarly paragraph 8. Therefore, it was retained and could not therefore transfer and converted as a riot dependent on the provision of section 6 subsection 1. Well, these are the argument which I could have understand was made by the state before the civil court.
An elaborate judgment has been written. An elaborate judgment has
No,
been
this
written.
is the state of judgment. From there, my lord, your lordship find all the judgment, your lordship, these suits are there, 57B, and Supreme Court said that, yes, those are matters pending. Be as it may, my lord, I am only relied upon two judgment of this honorable court. What will be the effect? এগুলো কোথায় রে? সাইটেশন হচ্ছে, তোমাকে আমি একটা কপি দিয়ে দিচ্ছি। WPLT number 218 of 2011. 281 of 2011. If your lordship will consider the entire thing, what the argument or the reason assigned by the authority concerned was considered, where your lordship will find paragraph 12 onwards, my lord.
Yes.
There was unfortunately SDO was and considered the same. The suit became final and binding upon no appeal was preferred. Here the state has preferred the appeal, but appeal was dismissed. The authority therefore has no scope to claim that the land in question vested to the state after promulgation of the State Acquisition Act, especially when the land revenue was collected from the mother of the petitioner long after the State Acquisition Act came into force. The Land Tribunal also not constituted whether the mother of the petitioner purchased the land from the vendors, namely Molliks, who were actually riots in respect of the land after promulgation of the West Bengal State Acquisition Act, since the land in question was settled in favor of the Molliks in the year 1939 by the Sri Chandra. The West Bengal Land Tribunal had no scope and no authority to decide the correctness of the judgment and degree passed by the competent civil court. As the judicial review, the Learned Tribunal could not upset the said degree which was passed by the competent civil court long before the constitution of the aforesaid tribunal. In any event, even an erroneous order passed by the court of law will have a binding effect on the parties to the proceedings, even though the same will not have any binding precedent in respect of any other matter in future. After that, my lord, these Supreme Court judgments were considered. What will be the effect if a wrong judgment? Such and such. After that, in the paragraph 22, in the present case, junior land and land officer has no authority and jurisdiction to grant partas in favor of the private respondent, ignoring the order of permanent injunction granted by the competent civil court. That is, the said junior landlord was under obligation and duty bound to take note of the degree passed by the competent civil court and had no authority to take any steps to frustrate the judicial order. Pause there for a moment. The same direction was passed by your lordship while forwarding this matter for consideration. You should take into consideration the judgment and degree, because the competent court of law having jurisdiction, part of the judgment is binding upon the parties. The Islamic tribunal.
Terms of the judgment.
Yes, that's why, my lord, because this paragraph is facts of this case, my lord, is also in my case also. The Learned Tribunal surprisingly did not realize the order passed by the competent civil court in citation and were finally binding in respect of the parties to the suit. And since the state of West Bengal is admittedly a party in the suit, the concerned junior land and landlords could not refuse to correct the record of rights and in questions by civil court cancelling the patta where the legally granted in favor of the private respondents in violation of the aforesaid degree passed by the civil court. After that, my lord, it was held, paragraph 26, my lord, the competent authority namely decided to take necessary steps for correcting the record of rights. On that aspect, my lord, it is a settlement of the water bodies. Now, my lord, if your lordship may kindly consider, apart from that, this is Honorable Apex Court. Okay, just, in দাদা আমি আবার তোমাকে দিয়ে দিচ্ছি হ্যাঁ সিভিল আপিল নাম্বার 7691 of 2022 দাদা আমি তোমাকে দিয়ে দেবো এগুলো হয়নি এখনো আমি দিয়ে দেবো দাদা
Yes.
if your lordship may turn to 9.4 it is hardly needs any overemphasis. My lord got it.
Yes, yes.
But for the doctrine of residuated, the rights of the person whose remain entangled and endless confusion at the very foundation of the maintaining the rule of law would be in jeopardy, even if the doctrine carries some technical aspects as explained by this court in such and such. It is the interest of the public at large that finality should be attached to the binding decision of the courts and competent jurisdiction. And it is also public interest that the individual should not be vexed twice with same kind of litigation as noticed in the Constitution being placed doctrine of high pedestal, treating to be a part of rule of law. Having taken into comprehension of the object and framework of doctrine of residuary, a few ancillary principles relevant to the case at hand may also be usefully noticed. The principle that doctrine of residuary is attracted not only in separate subsequent proceedings but also subsequent stage of the same proceedings is hardly of any doubt or dispute. This is also such and such underscored the principle of law in the following terms. It is well settled that the principle of residuary can be invoked not only in separate subsequent proceedings, they also get attracted in subsequent stage of same proceedings. Once an order made in course of a proceeding become final, it will binding upon the subsequent stages of that proceedings. Here, my pause here for I need to. It is well settled, law laid down in several decisions, even an erroneous decision remains binding on the parties to the same litigation, and concerning the same issue, if rendered between the same parties by a court of competent jurisdiction in the case of such and such, the court entirely has said, the law is well settled that even an erroneous decision inter-party judgment binds the party if the court competent jurisdiction passed. So there is no allegation that civil court has no jurisdiction. And my lord, the entire thing was considered, my lord. One point, my lord, I want to argue on this, my lord. If your lordship may kindly consider 11.3.
Fresh consideration has been made, in fact. Without going into
It is adjudication by title. What authority, my lord, today I'm using this word, don't forgive me, my lord, how this authority can decide or adjudicate a degree passed by competent civil court? What authority he has? He can say, yes, it is something else. State can prefer an appeal. It is not that behind the back the state, this degree was passed. Whether 57B is there or not, that is, whether this suit for, it is simply a suit for title. Section 34 of the Specific Relief Act. Whether it is barred under Section 9 of the Civil Procedure, I am not challenging any record because record of rights does not confer any title respect to any property. Irrespective of whoever the record of rights whose name is appearing or not, it is my lookout. My lookout is, my lord, whether my title is there or not. I have the civil court, competent civil court, in presence of the state passed a degree in my favor.
matter, yes.
So how does this authority can review the judgment of this civil court?
Let us hear the state. That's all your submission?
Yes, these are my submission.
The state has certain appeal over the order of a court.
Well, under Section 57B, my lord, there is a bar of the civil code regarding vesting matter.
The order has not been challenged.
The state by operation of law.
Judgment has not been challenged. It was passed in presence of the state. It will not be required because it's a question of law. There are no factual issues involved. Will you come back with a report in that case?
Well, only one thing, my lord. Initial grievance was that government is issuing parta in respect of their land.
You are the requiring body.
I'm but the private respondent. That was, my lord, sent for consideration. The authority found that they are the post-vesting transfer in respect of the land.
Yes.
Now, my lord, my humble submission is if they are aggrieved by the order of vesting or anything under the Estate Acquisition Act or the Land Reforms Act, then, my lord, their remedy is before, my lord, the tribunal.
There is a decree of the civil court. There is a decree of the civil court declaring the right title interest of the petitioners.
Lordship.
The decree is not under challenge. The state has not challenged. So
Challenged, but failed.
Can the state go beyond that? All this vesting and all these issues are all subsequent to the decree. So how can the state go into that? Isn't it? It's a pure question of law. A decree of a competent court stays at our case.
And
How
we are
can
in
the-
possession as per the parta issued by the authority, my lord.
Well, that is disputed, my lord. The position was not with my learned friend's client. They intended to issue the position over the plotting question. Last occasion, my lord was pleased to direct to pass a status quo order till that, and that was continuing. There is no dispute about the same.
Please come back with a report. Affidavit is not required. Why affidavit? কিছু দরকার নেই, state is buying time. Let them come back.
Acha, my lord, I am praying for the status quo to be maintained.
That is continuing.
No, it was till the decision of the last order, my lord, page.
There is no status quo.
Yeah, yes, my lord, your lordship will find that is at page 86. Page 86, last but second paragraph. Pending disposal of the representation, page 86.
That is in the earlier.
Yes, that order of status quo was there. Page 86, last but second paragraph, subject question. Pending disposal of the representation, there shall be an order of status quo upon the parties in respect of the position of the property in question on the.
So the same order.
The same order. I'm not.
Status quo. Since you're about, you want to come back on affidavits. Affidavit of service. Heard learned counsels for the parties. Paragraph, learned counsel for the state respondents seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks. Within 4 weeks from date.
Okay.
Paragraph, affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, let the matter go out of list for the time being. Paragraph, liberty to mention. Paragraph, let there be an order of status quo upon both the parties in respect of possession of the property in question until further orders.
Good for you.
Lordship, I'm appearing on behalf of the petitioners. I'm being
Yes.
led by Mr. Aniruddha Chatterjee, and due to his personal difficulty, he is not in the court. I'm praying for a nod today.
You have not used the exception also.
Your Lordship, we shall do it. I'm just,
That on the next-
yes, Your Lordship, I shall.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th September.
Your Lordship, the interim order is
Yes, I
expiring on
was
the,
waiting for your submission. Paragraph, the interim order granted earlier is extended till 30th September or until further orders, comma, whichever is earlier.
obliged, Your Lordship.
Next.
দাদাকে দেখলে ভয় লাগে তো।
Mr. Banerjee for the state?
I'm for the state. I'm for the KMD.
Yes, okay.
আমার কাছে আসছো
আমাকে সরিয়ে দিল। The land, my lord, was acquired. Not in its entirety, but a portion of the same. My lord, your lordship finding and drawing lordship attention straight to the reply given by the authority concerned in terms of our application that your lordship find at page 18. P1 to this application. The plot number is 2653. Which is the subject matter of dispute, my lord. Your lordship find plot number with acquired area is 0.34 acre in eastern portion. So for the other plots, I am not. The 0.34. The entire plot of land is, my lord, 60 acres of land. We prayed for that it should be demarcated only for that purpose. Then in any event cannot ask for anything more than 0.34.
Yes.
No, we have acquired and handed over to the requiring body. That's the primary instruction.
Mandatorily.
Under the statute.
Today I don't have not the.
And the law has been acquired in two phases. The first phase is what my London has shown at phase 18.
34 decibels.
Subsequent phase that has got mentioned by my London. And you can see this.
This was the rest portion, remaining portion, that is 0.26 acres, has been acquired in connection with LA case number 2/2, that is Roman 2/2 of 1993-94. And section 4 was issued by notification number 5605 LA 19 of 95. Dated on
Let my land friend report. So if it is found that, then I will not ask.
and then found out that thereafter, after due acquisition of the land was transferred in our favor by executing date of content. That is that we
Do you have a report ready with you?
really might not can see my note.
I want to keep it on record.
Then I have to file it. And it's all now, my lord,
No, your
Yes, I'm not disputing, my lord.
Your submission is sufficient.
I'm not disputing by Minister Talukdar.
Will you take instructions and come back, Mr. Roy?
all this.
So I need a copy so I can ask my client, yes, these are the copies, what is your answer? Because otherwise, keeping pending this matter doesn't suffice any purpose.
Because yes, this matter will not really serve the
Yes.
purpose.
If it is acquired,
So please come back with a report in that.
May I have a copy of the report so I can?
Yes. If I file it, suddenly you will get it.
Affidavit of service.
Give me 10 days time.
দেখো মুকেশ সঙ্গে বসো রিপোর্টটা নিয়ে যদি আসলে
Contended on behalf of the petitioners that out of a total area of 60 decimals in plot number 2653, comma, Moja, Kosh,
আমি আসবোই না মানে ইয়ে করতে
comma, land measuring more or less 34 decimals was acquired by the Kolkata Metropolitan Development Authority. Stop.
সেই বলছি যদি
The remaining 26 decimals are in 26 decimals are in possession of the petitioners. Stop. The petitioners seek demarcation of the acquired portion of the land. Paragraph, it is submitted on behalf of the KMDA that the entire land comprising 60 decimals has been acquired by the KMDA vide two separate LA cases. Stop. Learned counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on after after 19th September. Right? You have the documents ready with you.
He's overburdened.
He's keeping the arms under his bed.
13th, sufficient time. 13th September. One.
Report by state also. Because
I shall get the instruction, but let him file the report. I'll also get my instruction. But since they are in possession, they must be happy.
Learned counsel for the যেখানে এটা বলো, let the matter appear এর আগে করুন report file এর যেটা, তারপর learned counsel for the state respondents also seeks to take instructions in this regard. Yes. তারপর let the matter appear.
report না দিলে stand করবে।
30.
I am for the West Bengal Mineral Development Corporation.
I am for the petition.
আমি petitioner নই।
তুমি কার?
Mineral Development. Mineral Development আসলে। West Bengal
It's
Mineral
state.
Development.
Lord, I am for the Durgapur Project Limited.
I beg to appear on the state respondents.
My lord, the matter is, my lord, the petitioners herein are the owners of were the owners of a land, my lord, at Moja Paharpur in the district of Bankura, my lord. Subsequently, my lord, the respondent authorities, that is the Department of Commerce and Industries, my lord, they have decided to start several mining zones, my lord, in the district of Bankura under, my lord, Borjora, my lord, Borjora block. But thereafter, my lord, to that, my lord, necessary steps were taken. Interdepartmental communications were done by the respondent authorities. My lord, to that, a decision was also taken, my lord, to my lord, initiate acquisition proceedings and to compensate the petitioners, my lord. That was taken. But my lord, without initiating any acquisition proceedings, my lord, this land is being utilized from 2015, my lord. And my lord, there the soil is being stacked. My lord, the mining drainage water, which is coming from the land, my lord, that is ruining the other parts of the agricultural land. My lord, to that we have made repeated representations before the authorities. Your lordships kindly consider, my lord. The representation starts from page 69, my lord.
Yes.
My lord, that has been done. To that, my lord, annexure P6, my lord, they have called a meeting, my lord. My lord, in the meantime, the Durgapur Project Limited was delegated with the power to manage and supervise everything with regard to that mining block. Subsequently.
After 2000.
My lord, the Durgapur Project Limited assured us that, my lord, they will solve such problem. To that, a meeting was also held, my lord, on 28/12/2021. My lord, that is at annexure P6, my lord.
Page.
Page 90. Page 90. A meeting was held. Thereafter, my lord, no steps have been taken till date, my lord. My lord, our only prayer is that either the land is to be returned back to its original position. Otherwise, my lord, the initiation, my lord, the acquisition proceedings should be initiated in provisions with the law. This is our only prayer, my lord.
What was the decision taken in the meeting, the resolution?
My lord.
No resolution taken in the meeting.
Well, only it was assured that such.
Our package is next for
No.
my instruction is there is a the district magistrate has already approved the ROR package.
Approve the?
ROR package for rehabilitation of the.
No. That is not within our knowledge.
Position to say yes.
Lord, several representations have been made, my lord. And my lord, if your lordship so desires, my lord, I file a report, my lord. What actions, my lord?
Let him come back with the report.
My lord, lordship, certain.
Stating that the present situation, the present position.
Present scenario, my lord.
Yes.
Lordship, present state of affairs.
The petitioners claim to be the recorded owners of the land in question and complain that their agricultural land
Where the recorded owners? সেগুলো তো সাবসিকুয়েন্টলি হয়েছে আগে তো আমরা ওনার্স ছিলাম
is being utilized by the Department of Commerce and Industries, Government of West Bengal.
The subsequently land has already been vested.
Subsequently it was vested, my lord, for conducting, my lord, mining purpose, my lord.
Say that. Your lordship is.
No, I have told that, my lord, petitioner were the owners, my lord, subsequently
They were the
decided.
owners, but thereafter lands are vested.
My lord. No, sir.
Now the question is rehabilitation.
Under compensation.
Nothing else.
Utilized as a mining zone. Stop. The land has been subsequently vested. Stop. The petitioners claim rehabilitation.
My lord, rehabilitation and compensation, my lord.
Rehabilitation and compensation.
That is the only issue.
Stop. Paragraph, learned counsel. Only the state needs to come back with a report or the others
Yes.
also? That should be sufficient.
I think we'll.
Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 18 September.
Lordship, as a lordship,
Please serve advance copies.
lordship.
I'm grateful to your lordship.
If my lord, after seeing my lord's report, if we required, we shall. Thank you. Great.
31.
Yeah, that is different.
My lord, here is the affidavit inside.
I appear on behalf of the private respondent.
My lord, here, my lord, the private respondent's father sold out the property in favor of the petitioner. After purchase, my lord, their sons are not evicting, they are not vacating the premises, then my lord to file a suit for declaration and for eviction. Suit was decreed in our favor. They prefer an appeal. Appeal is pending. In the meantime, what they did, my lord, in front of my house, my lord, over the PWD land, they started to construct the house, blocking the entire, my lord, passage for the egress and egress.
So, my lord, we put an application before the executive engineer and other engineers. That is still pending. That was not considered. Kindly take up the page 24. 24. Page 24, the executive engineer, my lord, received. Then my lordship will also get a page 26. But the authority received, they ought to have started proceeding under section 10(2), 10(3), my lord, that was not started. Hence, my lord, we approach before this honorable court.
You're asking for consideration of both these representations?
Yes, in terms of the section 10(2) and 10(3).
Yes, my lord.
My lord, the suit property involved in the suit and the allegations made are completely identical, my lord. That is pending.
Can there be a suit under the West
No,
Bengal
no, my
Highways
lord,
Act?
I'm not praying for that. They have filed a suit against me. That suit was decreed in their favor.
That is in
I have
respect of the private property.
yes, my lord. That is in
That's a
respect.
different issue altogether.
And
That
kindly,
is
my lord,
separate
sees their allegation. What is their
It's encroachment.
kindly, my lord, sees where
Do you
they
have
have
the plate?
stated. Yes, my lord, I have.
Please show me.
Page 5 is their prayer and page 6 is the property, scheduled property.
Page 5.
Page 5 is the prayer, my lord, and page 6 is the scheduled property. হ্যাঁ, হুম, হুম। এই সাবেক এই দাগেই হচ্ছে সুটটা ফাইল করেছে। এই সাবেক এই দাগ। 1154 তো এখন এলারে এই সাবেক এই দাগেই সুটটা ফাইল করেছে।
Yes, this is the property of the petition, of the property in dispute in the suit. It's
Yes, ma'am.
cannot be.
My lord, this is separate portion. My lord, I have come before the lordship, my lord. After that, my lord, the entire, my lord, PW, over the PWD land, they constructed the house by blocking my passage. So, my lord,
The suit is not with regard to the PWD land.
no,
The PWD land is kindly
Adjoining
not
the
sees
petitioner's property.
adjoining the
The suit is with regard to the petitioner's property.
yes.
So this is not a bar.
Kindly not records my submission.
Yes. Affidavit of service. It is contended on behalf of the petitioners that the predecessor in petitioner adjourned. Predecessor in interest of the
yes, yes,
respondents.
yes. Private respondent,
That the
predecessor, my lord,
predecessor in interest of the private respondents transferred the plot in question in favor of the petitioner by virtue of a registered deed dated 19th July 1983,
yes,
despite which the petitioners despite which the private respondents refused to make over possession of the plot in favor of the petitioners, for which the petitioner filed a title suit
being title suit number 25 of 2013.
Yes, 25 of 2013 before the civil court
Learned First Court of Civil Judge Javannagar.
was decreed in his favor. Stop. The private respondents preferred an appeal against the said judgment and decree, being title appeal number TA number 51 of 27, which is pending. Stop. Paragraph, learned counsel for the petitioner submits that that during pendency of the appeal, the private respondents have raised illegal construction by encroaching upon a portion of the PWD road adjoining the petitioner's property, petitioner's asset for apostrophe property, thereby, no, sorry, petitioner's property, apostrophe S, thereby obstructing his egress and ingress. Stop. The petitioner submitted several representations before the concerned authority in this regard.
Page 24.
Within bracket annexure P3 and P4
Yes,
and P4 to the writ petition, bracket closed, which are yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the property which is subject matter of the title suit / title appeal is identical to that of the writ petition. That is your submission. And the appeal is still pending. Paragraph. The paragraph, it is not in dispute that the title suit was filed by the petitioner in respect of his property, which was purchased by him from the predecessor in interest of the private respondents. Stop. The writ petition pertains to alleged unauthorized construction upon the PWD road adjoining the said property. Therefore, the subject matter of the writ petition is distinguishable from that of the title suit / title appeal. Paragraph, learned counsel for the state respondents submits that the fourth respondent be directed to deal with the representations in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representations submitted by the petitioner within bracket annexure P3 and P4 of the P4 to the writ petition, bracket closed, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
My lord, respondent number 4 and also my lord 3, the executive engineer. আচ্ছা, ঠিক আছে। All right. Lordship would.
So 17. Suit 25 of 13, 51 of 17.
My lord, affidavit service may be kept.
Take it.
সুটের কাগজটা আছে
Which one? 32. Plaintiff কাগজ return করে দিন। 32.
My lord, in this matter, and for the petitioner on the self-same issue, my lord, a matter is pending before the Honorable Division Bench, my lord, which is fixed for hearing on Monday. And your lordship has been pleased to fix other similar matters on 15th of September. So let this matter be also fixed on 15th of September, my lord.
Very good.
Grateful to your lordship.
You are the petitioner?
My lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
15th September, my lord. Grateful to your lordship.
33.
But last order, my lord passed. That well, initially my lord directed them.
In this matter, Mr. Sanjay Shah is appearing for the West Bengal Mineral Development Trading Corporation.
Yes.
My lord. So he could not come to court.
He has got no role. Let me, every time you are taking adjournment, every time you are taking. No, he has got no role. Let me start, my lord. My position, my junior position will be precarious.
My lord, this
Every
is the first
time it is
that
given.
the West Bengal Mineral Development is
Not
taking.
taken earlier.
My lord,
Adjournment was not taken earlier. It's a predicament of the learned counsel.
no, my lord, kindly appreciate, Lord, I could have understood, my lord, that well, their presence, without their presence, matter cannot be heard. Kindly see the last order. They did not file any report. They are no way connected, but
They are parties to the writ petition.
yes, that's true.
Their absence.
No, but did they file any affidavit? No. Did they contest it in everything? Did they utter a single word? That is why I pointed my lord, the last order passed by lordship that well.
Okay, please come back. On prayer of the WBMDTCL, the matter is adjourned. Paragraph, let the matter appear on the same
ম্যাটারের কথা
heading.
বলিস না, অনেক শুনেছি ছাড়। ড্রিঙ্ক করছে বাড়িতে বসে।
6th September.
My lord,
Sixth September.
as well.
Your lordship.
A little bit high, my lord, otherwise, my lord. Take to earlier.
Earlier to that, how next week not possible?
ও তাহলে জাজ সাহেবের পছন্দ না কি করে এরকম বলে অত আবদার করলে হয় না I mean, one thing I'm, but though it is not normal.
We are in the last week of September.
No, no, my lord, it's all right. No, no, it's 60. Everybody is suffering with anxiety because of the mock kill. আমারও সেই অবস্থা. I mentioned what matter, my lord, and then my lord was kind enough to say it will appear in the supplementary list. It appears. Subsequently disappeared. I mean, the predicament of the notice. Again, I'll mention on Monday. Kindly let it, my mention with notice. Let it appear in the supplementary list.
Yes, I do not know why it is not appearing. Please give the
Then-
number on the next day, on Monday.
After all, my orders is there. I mention. I'll mention.
Mention on Monday. I'll
May I leave, my lord? Sorry to disturb your lordship.
Next.
Number
34.
I'm for the petitioner. Petitioner and her family are residing 35 years in the Jungle Khas
Respondents, Mr. Dev.
state. Jungle Khas area. Only DM, my lord, I am praying for Patta. Only
You are praying for Patta.
representation has been made to the DM, my lord, only.
He has got any deciding homework for that is you wanted.
Deciding?
Deciding home.
But Jungle Khas area. P annexed P6, page 18, my lord, DM, my lord.
Serve the municipality.
Municipality has no role, my lord.
So, but you have implemented the municipality as a party and you say no role. If no role.
And
you
I'm
have not implemented.
deleting, expense.
Yes, you delete.
Expense. Similar order has been passed by the Honorable Justice Sabyasachi Bhattacharya, similarly considered. Consider to sir.
Representation at page.
My lord, page 18, annexed P6. Page 18, DM.
You want settlement of the land in your favor. Let this be considered.
Yes.
Affidavit of service. Owner Tarakono on prayer of the petitioner. Liberty is granted to expunge the name of the fifth respondent, the chairman, Jhargram municipality, from the cause title of the writ petition. Stop, the cause title be amended accordingly. Paragraph. The petitioner contends that he has been residing with, contends that she has been residing. She has been residing with her family members in the plot in question for over 35 years. In the plot in question, okhane korun, which is vested land, comma, for over 35 years. The petitioner submitted a representation before the concerned authority seeking settlement of the plot in her favor. Representation before the authority on 20th March 2020. 20th March 2020, seeking settlement of the plot in her favor, comma, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the, who should consider Mr. Dev?
My district magistrate.
District magistrate. The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing.
My lord, within 2 months, because my lord will take the report from the PLR, whether he was.
Within 2 months. 2 months, no? Opportunity of hearing to all the stakeholders. To all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
And next is also same, my lord.
I'll just call them.
Instead of
I'll
he,
just call them.
she.
Next. 35.
Same lordship. Representation, my lord, page 20, annexure P7.
State.
I have, my affidavit.
Affidavit of service.
Annexure P7, page 20, lords.
You'll expunge the municipality?
Yes, lords.
Mr. De, may I request you to similar one?
Instead of C, my lord, he, it is.
Page.
Page, my lord, page 20, P7.
On prayer of the petitioner, liberty is granted to expunge the name of the fifth respondent, the chairman, Jharkhand municipality, from the cause title of the writ petition. Stop, the cause title be amended accordingly. For affidavit of service, none appears for the state respondents despite service. Mr. De, who is present in court, regularized court. Please serve a copy of the writ petition. To Mr. Copy service direction. তারপর আগেরটার মতো same order. He's কিন্তু bail person. Date 20th March 2020. Within 2 months.
Yes.
এই দুটো তো 36.
36, I am appearing for the petitioner, but here my affidavit of service. 28A application has been filed. It has been filed on 6th of May 2014. It is not affidavit of service.
For the respondents.
But in the next matter, Mr. They, several 8 similar matters are there appearing in the list. In the next matter, Mr. They is appearing. Already it shall be directed to be disposed of.
So may I request Mr. De to appear served? Where is your application?
No, that is my application. First application is at page 10. They did not file any reference. The LA judge passed the order on 12th of March 2014. Immediately we obtained for certified copy, and 25th of March 2014 we have filed. Within 12 days from the date of the judgment we have filed. Since then it is pending.
So then let it be considered. Yes, madam. Affidavit of service, none appears for the state respondents despite service. Mr. De, service regularized. Please serve a copy of the writ petition to Mr. Please serve a copy of the writ petition.
Yes, Mr. De, Mr. De, I am serving me.
Copy service
First matter Sondike একটা copy দিয়ে দাও।
by the compensation.
পরে xerox করে। হ্যাঁ, রাজু গিয়ে পাঠিয়ে দিয়ে আসবে। লিস্টটা থেকে লিস্টটা দেখে
award.
Landation कार्यक्रम बारासात not
Determined by the
আর এটা থেকে আছে 38 তাহলে আমি চন্ডিকে দিয়ে দেবো চন্ডিকে
determined by the learned land acquisition tribunal.
my lord.
The award was by the tribunal.
Yes.
Yes.
Generally land acquisition judge, your lordship in district court.
That is the tribunal.
That is the tribunal, land acquisition tribunal, LA judge.
The petitioners filed an application under section 28 capital A of the Land Acquisition Act
28A what?
1894. seeking redetermination of the award.
Yes. In terms of
What is the
type,
date of your application?
my date of application is, my lord, 6th of May 2014.
28A যেখানে বলো ওখানে on 6th May 2014 for redetermination of the award which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that
Respondent number 3. Land acquisition collector.
that the third respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioner dated such and such, petitioners dated such and such within 2 months.
Yes.
Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereafter. Disposed of, which
আইন তৈরি করেছে তোমরা, আমরা কি করবো বলো? Next matter is same. Same. All same. Lord, here I am.
of petitioner একজন এটা where is the application? 6th May 2014. that was
Yes,
it.
all same.
6th May 2014. Same one. Yes, next.
Next number 38, I am serving copy.
Lord, how will serve? You know first who is appearing. I am appearing, Lord. I have been briefed in this matter. In every matter you are telling. Very bad practice. No, I am appearing. I have been briefed in this matter.
Here is
What is the matter about? Similar matter?
same matter, my lord. Same day, same 28, 6th May, everything same.
Let it be considered. The 28A application, yes?
6th May.
না না সব ঠিক আছে তোমরা এসে বলে দাও না লেট ইট বি অ্যাপিয়ার এগুলো ভালো না
Let it be appeared for this.
পরে বলবো বাইরে গিয়ে বল
The গাঙ্গুলি আছেন petitioner.
কোথায়?
Date-টা হয়।
কারোর পেটের ভাতের লাত
কোথায়
মেরে
দিয়েছো?
কি হবে গো
কোথায়? 8198 কোথায় দিলে তুমি? Evidence
Next.
side. This is my lord. The another similar matter are appearing in item number 55, all same. My lord, 55, 58 to 59, all same. Mr. Bandyopadhyay is appearing in 3 matters.
Let me call one.
Tell you.
39.
দেখে দাও।
39, my lord, I am begged to appear virtually, my lord, due to my viral fever, my lord. My junior was there, my lord, the court, my lord.
ভুলভাল হলো নাকি দেখ।
As per your, my lord, as per your lordship,
কোন
39, my lord, as per your lordship direction, my lord, I am served the copy to the my learned senior counsel, Mr. Chandracharan De, my lord. On the 18th August, my lord directed me to serve the copy. I have already served copy to him, my lord.
Yes, Mr. Dey, you're appearing. Yes.
My lord, in this case, my lord, in the year 1981, my lord, the petitioner got allotment of the land for construction of a chemical company, my lord. It's Kollani Chemical. And my lord, they are trying to set up the company, but due to the pollution control board, my lord, in the year 1981 onwards, my lord, they are unable to set up the petrochemical company and the Kollani Chemical Company established. My lord, up to 2005, my lord, they are trying to set up the Kollani Chemical, but they are unable to do so. So in 2005, my lord, they are trying to set up an agro company. That was also rejected by the government that it is not done by the, it is not able to file the, they are not able to get any permission. Thereafter, my lord, they are trying to set up a saline company, my lord, that was also not given by the government. Thereafter, my lord, the government gave a so cost to the company. Why you are not using the land so long? So company, this company gave a detailed reply to the government, to the so cause, but unilaterally without, my lord, any hearing, my lord, they are saying that we are entering into the land of the company.
Thereafter, my lord, in 2010, my lord, the petitioner filed an writ application before this honorable court, and honorable court directed the petitioner to get a order of the status quo from the concerned, my lord, this honorable high court. Thereafter, my lord, the petitioner, the government has changed, my lord, and the director of the company has also changed. The director of the company, my lord, the company is the same, but the director at the change, now the new director has come, but the company ownership has been changed. So they make a proposal to the, my lord, the estate officer to reconsider their prayer. So estate officer says, as there is a status quo order from the honorable high court, so we cannot go further. So they, the petitioner company, my lord, wrote a letter that the matter was amicably settled, so withdraw the matter before the honorable high court. We are withdrawing the matter before the honorable high court, and we are giving the project proposal to the concerned authority. But after giving the project proposal, my lord, they are not considering the same, and they are saying that there is a no matter now pending before the honorable high court. It is, my lord, in page 77 is the withdrawn of the order from the high court, and page 78, my lord, is the order passed by the authority that as there is a no status quo order from the honorable high court, so we are re-entering your land. Next, my lord, in the page 79, my lord, the writ petition, again the director of the company made representation. Thereafter, my lord, that was not disposed by the concerned authority till date, my lord. So we are now, thereafter the central government gave permission to produce, my lord, the medicines, and there is a construction is going on, my lord, and more than 3,000 youth, my lord, is working in the project, is working as a chemical lab in the chemical project. So my prayer is that, my lord, let the estate manager reconsider my prayer at page 79. My lord, kindly set aside the order and reconsider the present situation, my lord. Because, my lord, the construction is there, my lord, and more than 300 youths are working in the said area. Petitioner is getting the, my lord, all license. I have, my lord, annexed in my exception that the now petitioner is getting every license from the government of India and government of West Bengal.
Let it be reconsidered.
Yes,
Let
ma'am.
it be reconsidered upon
Ma'am.
hearing you.
Yes, ma'am.
Yes,
And in
Mr.
the meantime, my lord, no coercive step taken by the authority.
Yes, yes. Heard learned counsels for the parties. Paragraph, it is contended on behalf of the petitioner that the petitioner was allotted the plot of land in question for establishing an industrial unit for manufacturing chemical drugs and other pharmaceutical drugs.
Yes, ma'am.
Manufacturing chemical and other pharmaceutical drugs under the name and style of Kollani Chemicals and Pharmaceutical Private Limited. By virtue of a deed of lease executed on 21st January 1981 for a period of 999 years with effect from 19th August 1980. Upon facing certain difficulties in getting clearance from the Pollution Control Board for setting up the industrial unit, as well as labor problem at the material point of time, the petitioners were unable to establish the pharmaceutical unit and proceeded to set up a rice milling industry and thereafter what was the other industry that you wanted to set up after the rice mill?
Tablets and capsules, my lord. It is revealed from their report also, my saline, my lord, saline water project, my lord.
It's in a writ petition.
My lord,
Saline water project.
It is in the report itself, my lord.
And
The report filed by the state.
A saline water project which could not be started since no objection certificate was not issued in favor of the petitioners by the authority. Stop. The respondents issued notices upon the petitioners directing them to show cause as to why the land allotted to them would not be resumed upon cancellation of the deed for non-utilization of the land for a long time. Stop. The petitioners replied to the show cause notices, despite which the authority terminated the lease agreement unilaterally without extending an opportunity of hearing to the petitioners. Stop. The petitioners filed a writ petition challenging the said order of termination B WPA 3558 within bracket W of 2010. That's the number.
2010, my lord.
2010.
Page 59.
By an order passed on where is the status quo order?
My lord, page 61. Order dated 5th January 2010.
By an order passed on 15th January 2010, a coordinate bench of this court granted an interim order of status quo upon the respondents therein with regard to the plotting question. Stop. The petitioners approached the authority for permission to set up the pharmaceutical factory, but was informed that the same could not be granted due to pendency of the writ petition. Stop. In view thereof, the petitioners in view thereof, the writ petition was dismissed for non-prosecution by an order passed on 22nd December 2016 at the instance of the petitioners. Stop. Following the said order, the petitioners received a communication from the estate manager, Kollani Urban Development Department, Government of West Bengal on 18th May 2017, stating that since the writ petition was no longer in force, the letter of resumption issued on 1st September 2009 came into effect and the government would re-enter the plot in terms of the said letter. Stop. The petitioners submitted a representation before the authority on 19th May.
19 May 2017. ma'am.
19th May 2017, seeking reconsideration of the letter issued on 18th May 2017, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation submitted by them for reconsideration of the issue. Stop. It is submitted, paragraph, it is submitted on behalf of the respondents that the, who should consider?
That is respondent number 4, ma'am.
Fourth, that the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such 19th May 2017 within 1 month. Within 1 month from the date of communication of this
No
order.
coercive action, my lord.
Yes, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, pending, paragraph, the, disposed of it, it is not required to set aside the letter because it's only a letter saying,
We are re-entering into the. No, my lord, we are saying that no coercive action may be taken, my lord, during this time.
pending disposal of the representation, comma, no coercive action be taken by the authority against the petitioners in respect of the deed as well as the plot in question.
Deeply obliged, my lord.
Disposed of which are
Deeply obliged.